Still appeal 2021, madam. The Lordship directed to file appeal during this month. When I presented during January, madam. 2020 commercial.
Sir, Mike use my
Commercial appeal 2021, madam. When I presented the appeal memo during January, your Lordship directed to file submit now. Yes. Yeah, appointment. Of course, that is, no, I have not informed, but I will inform, madam. Yes, madam. Not definitely. Please, no, definitely. Madam.
Just take this.
Sir.
And take an acknowledgement. Please.
Number 47 in option. And for the appellant.
This is today's board.
Page number 9, 27 to 29. Page number 10, 30 to 34.
My lords, may I make a mention, my lords? Serial number 34, my lords. And for the respondent BDA, my lords, the appellant. Sorry, my lords, the appellant BDA, my lords. I've informed all the parties concerned, my lords. Request 2 weeks of accommodation, my lords.
Just say that at the request of counsel for the appellant for an adjournment by stating that he has informed all the counsels for the respondents, re-notify on. Yes, normal date.
16-6.
Grateful, my lords.
Page number 11, 35 to 40.
That's serial number 38. And here for the respondent in serial number 38. I've informed the appellant's counsel.
What is the difficulty, Ms. Renuka?
In fact, this matter was heard and your lordship suggested whether he could be reinstated or not. They're yet to take a decision.
At the request of the learned counsel for the respondent, re-notify on. You have informed the other side.
Yes.
She states that she has informed the counsel for the appellant.
17-6. Page number 12, 41 to 45.
My lord, serial number 44. I appear for the respondent, my lord. The argument counsel is unwell. The other side has been already informed, my lord. At least 2 weeks' time may be granted.
Which number?
44, my lords.
At the request of counsel for the appellant.
Respondent, my lords. Respondent.
No, you appear for the respondent?
Yes, my lords.
At the request of the respondent. For an adjournment on the ground that the counsel is unwell.
18-6.
Stating that he has informed the counsel for the appellant, adjourn to.
Serial number 41, Much my obliged. lord. Serial number 41, I'm for the respondent. Week's time may be granted. Madam. I informed the appellant also.
I have no objection, my lord. Kindly maybe undertaking can say may be continued, my lord.
21. Just say re-notify at the request of counsel for
Respondent.
respondent for an adjournment, re-notify 23-4.
Number 40.
40. Oh, no, 21. Oh. Okay.
Number 47 in lordship. I'm for the appellant.
Your lordship, in serial number 47, I'm appearing for the respondent.
Of counsel. Now, which is this matter now?
Number 47 in lordship. I'm for the appellant.
I'm appearing for the respondent, your lordship.
Yes, ma'am.
I pray for time. I pray for time, your lordship.
Pardon?
I pray for time.
You are for?
I am for the appellant.
Yes, ma'am, he's seeking adjournment.
Your
The
lordship,
counsel-
if the lawyer had informed me, made a personal request, today I don't have any objection, but it may be taken up in April, your lordship. It's a short point. The respondent had.
We will see that at the request of counsel for the appellant. Adjourn to
16-6.
next. Call the matters. You take care. Call them.
This number 3. Ravi Shankar.
The tenure was held as
Just for the state,
Please, my lord, presently.
you have the copy, writ petition.
Please, my lord, I have been.
Just say issue notice. Issue notice. So and so accept notice. Seek and is allowed. Mr. Yes, Mr. Beliapa,
Yes, my lord.
what you will
Sometime-
file your,
Yes. 3 weeks, my lord. 3 weeks. my lord.
3
Yes,
weeks.
sir. He was gambler.
Have it 2 weeks, Mr.
2 weeks, my lord. 2
2 weeks.
Yes.
To file a counter affidavit. Okay, re-notify.
27-3. List 1, serial number 1.
My lords, my apologies, my lords. I want to move a memo, my lords. It's a fresh matter, my lords, for admission, my lord.
What is the matter about?
My lords, arbitration appeal, my lord.
What is the urgency? Do one
My lord, we
thing,
need to stay the award, my lord. That is the reason.
you look into it, mention it after lunch.
Sure.
Okay.
Yes.
Yes,
I appear for the appellant. I had complied with the office objection the first time, but then again certain objections have been raised, my lord. I'll comply during the course of the day. I pray that it may be taken up on Friday, my lord.
just say that office objection be cleared within 1 week.
Date may be given, I'll comply.
Yes, date fixed.
24-3.
Great.
Serial number 2. Please, Sachin.
Your lordship, I appear for the petitioner. May be kindly passed over, your lordship, there.
Vilyapa, you have not filed your status report.
Yes, we have filed mistake. It reflects that it
You have filed it in the registry also.
registry.
You have filed it. You've got a copy of this.
Yes, your lordship.
What do you say?
The child is secure.
Secure?
Yes.
Your lordship, the petitioner father is.
Yeah, just call him.
May be kindly passed over, your lordship, that.
Can't pass it over today, difficulty. Call him.
Yes, yes, your lordship.
The child was taken to the father.
What happened otherwise? Just
The
tell us.
child would refuse to go with the parents. So
Oh.
therefore, he is in the child welfare unit referred by the committee, CWC.
No, he doesn't want to. Wait,
He is placed in a child welfare unit.
pardon?
He is placed in a child welfare unit by the CWC.
The petitioner father, your lordship.
Now, what do you intend to do it? Now tell us one thing. Now the child is secured now.
Yes, your lordship, the child is found, your lordship.
Then
Now the concern, your lordship, the parents, they need the custody of the child, your lordship. Right now,
is now a different
Yes,
action. Hmm?
because the child welfare committee has taken cognizance and they will proceed according to the procedure laid on
So
the
now
JJ
the
Act.
jurisdiction, you see, you filed a petition that the boy is not traceable. That's
Yes.
right.
yes, yes, your lordship.
So now boys, whereabouts of the boys have been traced out.
Yes, yes, your lordship.
They have an issue, the CWC.
Yes, your lordship. Your lordship, one humble submission.
And there is a process laid down, under for
Yes,
CWC will
yes.
take action.
Yes,
Your lordship, highlighting one concern, your lordship, in point number 12 of the affidavit filed by the learned counsel.
Yes.
Your lordship, therein it's mentioned the boy has refused to go with the parents. But the instructions what we get is the boy is actually willing to go with the parents, and
That will be looked into by CWC.
yes.
Now, do you give an opportunity to the parents also to
Yes.
interact with the child?
Yes. The first
Everything will
priority
be
is
sorted
that.
out.
The first priority is to hand over the child to the custodian,
That's right.
natural guardian or the parents.
But has the interaction taken place? No, has the interaction taken place with the parents of the child?
But we are not given adequate access, Your Lordship.
What do you mean by adequate access?
Your Lordship, the boy is one fact I would like to point out, Your Lordship.
You filed a petition that boy is missing.
Yes, Your Lordship.
The boy has been traced out.
Yes, Your Lordship.
Proceedings have been initiated by the CWC.
Yes, Your Lordship.
Then they will work it out. But tell us one thing, Mr. Biliappa, now, what is the follow-up action now you will take?
Now, this writ petition will become infructuous. Because he is not detained by anybody illegally, so therefore there is no detention by anybody. Even otherwise, it was a case of missing, and it was not a case of illegal detention.
Your Lordship, one submission, Your Lordship.
Now in a child welfare unit, which is enlisted by the CWC and recognized by the CWC.
Lordship, one submission, Your Lordship. The parent petition is present here, Your Lordship. They are not given adequate access to interact with the child. And one fact I would humbly bring before the Lordship. As soon as the boy was traced, Your Lordship, the first thing what he did was he called his mother, Your Lordship. In such a case, as per point number 12, pointing out that he's refusing to go with the parents.
Why do they want to keep the child? Tell us one thing.
So the petitioner parents are also going through trauma.
We'll defer this matter.
Yes.
Let's see what is the progress made at the CWC level. We'll have it next week.
Yes.
Just update us. See, he wants interaction. I don't think they should
Tomorrow
be.
we'll arrange
Just give a father, let the parents should have an interaction, let him they interact. Possibly they can prevail upon the child,
Yes.
or the child can prevail upon the parents. Either way.
And just one concern, Your Lordship, again, provided the parents also wanted to interact. The second PUC exams are still going on, Your Lordship. So some exams are still pending. So we are also trying to make out some efforts if he's willing to.
First, let this be worked out. Forget the exam, this be worked out.
Yes,
Okay?
yes, Your Lordship.
Let the parents.
The background is he was traumatized due to exams by the parents, so therefore he left.
Don't expect that kind of, don't put that kind of a pressure on the child.
No, that
Leave
is,
the child.
that is untrue, Your Lordship.
Very well. That's what he says. Very well.
Yes.
Just say that affidavit has, status report has been filed in the court, has been filed by the respondent. The same has been perused. Re-notify next week. We'll re-notify next week.
Yes.
Get your instructions.
Yes.
Can you file a memo, Your Lordship?
For what?
See
For what?
that we are willing to take the custody. Yes.
Let the proceedings be over. We are keeping ourselves before us.
Yes, yeah.
Okay? We will see it next time.
We will organize a meeting tomorrow.
Pardon?
We will organize a meeting between. the
Yeah,
parent and-
meeting. Let them have their meeting.
Yes, yes.
Let them, both of them interact.
Your Lordship, that may be kindly ensured, Your Lordship, the
Yes, yes.
regular
Certainly we will do.
access,
What do you want?
that may be kindly ensured, Your Lordship, access to interact with the child, Your Lordship.
The SPP has given the submission.
Yes.
We take that submission.
Yes.
If nothing transpires, inform us on the next date.
Yes.
He himself is saying that will be allowed. The interaction will be allowed. Let the parents be, Mr. Reliap.
Yes,
Interact.
certainly.
Yes.
In three. In please.
What's your pleasure?
Serial number 3.
You wait a respondent notes.
Waiting for the appellant. All the office objection have been complied, my lord.
Last hearing of
Yes,
All the office objections complied.
you have removed that one objection also?
Yes, my lord.
Yes. So what is your case?
Kindly pass on, my seniors coming.
See, we'll do one thing. We'll not pass over. We'll have it next week. Okay?
Please.
Though the learner counsel for the appellant states that the objection has been removed. Verify the registry to verify, though a passover is sought. It's not possible to pass over the matter, re-notify. Just give it next week any date.
20th?
Please.
Could it be on 19th or 19th, or
Yes,
one day later,
19th
20th? I'll
inconvenience
not
is
be in
there.
town.
19th inconvenience is the
We
senior.
need except 20th, just.
We'll see, just see that
Please.
whatever is convenient.
The 24th?
Please.
Please.
Serial number 4,
Serial
It's
number
a
4, government.
state petition, my lords. We have complied with all the office objections, my lords, so in respect of one office objection. It's petition number 5 and 6.
Yes.
It's petition number 5 and 6, my lords, were not arrayed as parties, my lords, before the Central Administrative Tribunal. Matter arises, my lords, out of a contempt proceedings. The then Chief Secretary and the then Secretary of DPR, my lords, were made parties by name. The first 4 petitioners, my lords, were the persons, my lords, who were occupying the officers who were occupying the said post, my lords, during the pendency of the contempt petition. But as on the date of the filing of the writ petition, it was petition number 5 and 6, my lords, who were the Chief Secretary and the Secretary of DPR. So we had made them parties, but now, my lords, respondent number 5 has retired. 6, my lords, is no longer the Secretary of DPR. So we may be permitted to delete both of them. Please, my lords. But petition, it's arising out of a contempt proceedings, my lords. Lords, order is that the order in the contempt proceedings, my lords, is a divergent opinion that we are not in compliance, my lords, of the order. Lords, it will give cause of action.
Press upon them and possibly like a petition against the order of the tribunal.
Please, my lords. Please.
Whether tribunal is exercising contempt jurisdiction under that provision of the administrative tribunal.
Please, my lords.
But as I also said so, on the maintainability, what you have to say, possibly. What is your
My lords, on the last occasion, I had challenged this writ petition on the maintainability aspect, my lords. As per Supreme Court decision in T. Sudhakar Prasad versus Government of AP, my lords. I have given a copy to them, my lords.
Please, my lords, I'm not aware of this, that they had taken up that contention. Please, my lords, I will look at it. Please, my lords.
just show us the judgment?
My lords, it is in the compilation that I have filed, my lords, at page number 51. I request your lordship's attention to page number 62, my lords. Para 16, my lords. May I, my lords? My lords, para 16, it is thus clear that the Constitution bench has not declared the provisions of Article 323A 2B or Article 323B 3D or Section 17 of the Act ultra vires of the Constitution. The High Court has in its judgment under appeal noted with emphasis the tribunal having been compared to like courts of first instance and then proceeded to hold that the status of administrative tribunals having been held to be equivalent to the court or tribunals subordinate to High Court, the jurisdiction to hear their own contempt was lost by the administrative tribunals, and the only course available to them was either to make a reference to High Court or to file a complaint under Section 193, 219, and 228 of IPC as provided by Section 30 of the Act. The High Court has proceeded on the reasoning that tribunal having been held to be subordinate to the High Court for the purpose of Article 226, 227 of the Constitution and its decisions having been subjected to judicial review, jurisdiction of the High Court under Article 226, 227 of the Constitution, the right to file an appeal to the Supreme Court against an order passed by the tribunal punishing for contempt under Section 17 of the Act was defeated, and on these twin grounds, Section 17 of the Act became unworkable and unconstitutional. We do not find any basis for such conclusion or inference being drawn from the judgments of this court in the case of Supreme Court Bar Association or L. Chandrakumar or any other decision of this court. The Constitution bench has in so many words said that the jurisdiction conferred on the High Court under Article 226, 227 could not be taken away by conferring the same on any court or tribunal, and jurisdiction hitherto exercised by the High Court, now legislatively conferred on tribunals to the exclusion of High Court on specified matters, did not amount to assigning tribunals a status of substitute for High Courts, but such jurisdiction was capable of being conferred additionally or supplementarily or on any court or tribunal, which is not a concept strange to the scheme of Constitution, more so in view of Article 323A, 323B. Yes, please.
Please, Manoj.
Ninth line, my lord.
Please. Got it. Manoj. While holding.
My lords, there was a divergent.
No, Manoj, it's not at the stage of punishment. Please. Please.
Still pending before the tribunal. And the scope of interference by the High Court is very limited. We will leave it to the tribunal. Now read first. However,
Any order.
order of decision of the tribunal punishing for contempt shall be applicable to the Supreme Court. Within 60 days from the date of the order appeal against any of the specific provision contained in the section 19 of the admit section 17 of the section 17 of the rules of legislation by reference provision of contempt of court are not as if incorporated in the text. They remain there where they are, yet by using the provision of contempt of court in the text of the chapter, the same will be so read as to direct the word tribunal in place of the word wherever it is subject to the modification. So one, no interference on the interim order. At the most, it's an interlocutory order of the tribunal. It's more. If there is a conclusiveness, you have a remedy before the Supreme Court.
If it is concluded, my lords, we have a remedy before the Supreme Court. But any order passed before the passed by the tribunal will, my lords, be available to 227, my lords. Please, no, it's not. But I'll rely on Chandra because, my lords, please.
And so would be available to the jurisdiction of the High Court under Article 226, 227 of the Constitution, subject to well-established rules of
Self-restraint. Please, my lords.
Pending proceedings and absolutely or an interlocutory order of the tribunal.
Please, I'm getting the point. My lords, that is the position. But, my lords, non-granting of interim orders, my lords, petitions are being entertained by this honorable court by either the CAT or the Karnataka State Administrative Tribunal. Not only that, my lords, insofar as where our reply is rejected and the matter is posted for framing of charges, so there that is a stage, my lords. I get it, my lords. In the scheme of the contempt proceedings, it is an interlocutory order. It is not a final order. Thereafter, charges is going to be framed, and the trial is going to happen, and thereafter I'm going to. My lords, I'll reply to this, lords. Please, my lords, the office objection could be overruled. I may be permitted to delete petition number 5 and 6, my lords. They were not parties before the tribunal. That is the office objection. Please, my lords. 5 and 6. 5 and 6 minutes, both. Please. That's all. That is the office objection. We are not pressing as against 5 and 6. Please, minutes.
The authority to implement the order.
Please,
He would be the proper and necessary part.
please. Minutes. I will get to that, minutes. It's a stage of framing of charges, which is a drastic consequence. So therefore, I'll come. I got it, minutes. I understand where my notes are coming from. Please, grateful.
2nd of April. Serial number 5, Sampath.
Thank you, my lords.
In this, for appellants, my lord, I filed an application 1 of 25. My lords, this honorable court, my lord, it's a commercial court's order, my lord. I've been directed to pay certain amounts.
Respondent.
Interim order was passed by my lords on 8/11/2024. Lords, I paid my lord out of 5 crores. Lord, 1 crore 77 lakhs I paid in one installment, my lord. And recently I paid 25 lakhs. No, my lord, because of my business, my lord, I've been struck with some amount needs to be gathered. Please, my lord. No, my lords, one submission, my lord, I have, my lords, certain proceedings are initiated by me, my lord, in which I need to get the amount. Please, my lord.
Yeah.
Please, my lord. No, my lord, so my one submission is that, my lord, I'm ready to pay it, my lord. My lord, so, if I just take request, my lord, to the application. My lord, I mean, initiated a contempt against, my lord, the state. Lord, I need to get amount from the state, my lord. It's on 28th. Once I get the amount from the state, my lord, because it's an iron ore business, my lord, I do. Lord, the learners that was struck in a criminal court, my lord, again, under a writ petition, my lord, I've been favored. SLP has also dismissed, my lord, in a contempt proceedings, I've been expected to get this certain amount. Lord, until that, I get that amount. No, my lord, it's a contempt, my lord, it's going on. No, my lord, please, my lord, but please, my lord. No, my lord, it's
Only one submission, my lord. They've been in flagrant violation of your lordship's direction on 2 occasions. At the first instance, the amount that has been, they have suffered a decree for, as your lordship knows, 10 crores and odd. Your lordship had directed them at the first instance to deposit 5 crores rupees. They failed to do so. And then on the last occasion, 1 crore and 77 lakhs, 27,000 was deposited. Thereafter, your lordship, they said they will pay the amount after 2 months' time. At the first instance, 2 months' time was granted. They came up with 1 crore and they did not come up with the 5 crores as directed by your lordship. Now again, they make this application over here. It's only a ruse to avoid payment. It's only a ruse to avoid payment. Lord, beg your pardon. I'm opposing the.
On submission, my lords, the amount that they were calculated, my lords, the decretal amount is only 3 crores, my lord, along with the interest, my lord, we said. My only submission is that, my lords, my lord, that, please, my lord, that's all, my lord, I am not saying that I will not. Please, my lord. And we also said, my lord, that 8/11/2020. Please, my lord. On that day, my lord. Please, my lord. Please, my lord. The liberty was reserved me to make some objection if there is any on the memo. My lord, that's I will not revisit, my lord, because I will not trouble. My lord, it's only humble submission in my application, my lord. That's why this I come up with this application. I will furnish my property as a surety, my lord, for the remaining amount, for the part complaints, my lord, for the whatever amount. As and when, my lord, I get the amount, my lord, I will deposit before this one. My lord, to show my bona fide, I also produce all the proceedings, my lord. In my application, my lord, page 44, my lord, is the contempt proceedings, my lord. Lordship, 43 is the order sheet of the contempt proceedings. Let's say 44, my lord, is the order of the Honorable Division Bench, my lord, 17/12/2024.
So this was not the submission made on the last occasion when they undertook to pay, my lord.
Lords, we are ready to pay, my lord, since the amount is stuck, my lord. That's what, my lord, we just. Please, my lord, my lords, Lords, because of shortfall of the amount, my lord, we are ready to furnish the property. Lords, some, please, my lord, totally, my lord, that's what I came up before furnishing my property as a surety, my lord, until the part. Lords, I showed my bona fide paying the amount, part amount. For remaining amount, my lord, I produced all the order sheet or documents, my lord, to show that some amounts are lying with the states, my lord. I totally understand. Please, my lord. Please, this application, my lord, lordships may consider, my lord, I'll just leave it to this on the application 1 of 24 lordships may consider and dispose it of. To seeking permission to, my lord, furnish property
Only
for
one
this
submission,
remaining
my lord.
complaint.
Whether the application is maintainable at all in the wake of the fact that earlier they have given an undertaking to pay, and now they come up with this application just to drag the matter. Whether the appeal is maintainable at this juncture without complying with the order of the court.
Lord, so regarding that, my lord, I just asked with my claim. No, my lord, see my lord, the SLP is also closed, my lord, contempt, my lord, that is what, my lord, I just, the order sheet of the honorable, in the contempt proceedings, my lord, lordships may kindly note. My lord, the SLP is also confirmed. It's not that SLP is pending, my lord, contempt will not. SLP is also closed, my lord, it's in my favor. Against which, my lord, the order of the learned single is favoring me, my lord. The state went to the SLP. State was unsuccessful. No, I initiated a contempt, my lord, I will get. Please, my lord, that contempt, my lord, was not there on 8/11, I guess, my lord, please.
Was there on 9th of January?
Lords, it was, lords, because the order of the learned. Lords, I have
One or the other ground is there, suspect every date of it.
Let's say.
Yes.
Please, I have one copy. Another copy for convenience. Please. That's the property that I sought to be. Space 7 is my property for which measures 10 acres. Please, man, just. Please, man. That's the only submission is that the only contempt, my lord, that's was the only hope, my lord, because I have no money, my lord. That's the only, that's the, my lord. Lords, we were expecting, my lord, the amount from the state, my lord. Please, my lord, it was in place, my lord, they were in the SLP. Lords, sir. Please, my lord. But we tried to secure the amount, my lord, that was not, please. Please, because we are deposited one crore. Please. Please. Please, oblige me. Please, my lords, now it has to be heard and the records may be called for, my lords, it has to be.
What about the only one submission? What about the rest of the amount they'll have to? Very, very well.
23-6.
For the appellant's counsel.
Twenty-five-3.
Please. Yes. Yes. ma'am. Yes. ma'am. Yes. Yes. ma'am. Please.
7. Serial number 7, she.
Respondent. My lord, I object for that, my lord. Last occasion also they took Passover. It
But
never
there is-
reached, my lord.
My lords, if I may humbly submit, there's a special bench matter on photos. My lords, there's a special bench hearing in 7. He's he's on his legs, my lords. My lords, at 2:30, by 2:30, it'll get over for sure. My lords, because there's a special bench, it's going on for quite a long time. My lords, it will already take in challenge in that case, my lords.
My lord, a very small point is involved, whether it is maintainable.
It is
Please, my lord.
I assure. I assure. Please, ma'am.
Serial number 9, Sri Nagendra ma'am.
For appellants, my lord, we comply with office objections.
Respondent number 2. My lord, here last almost 10 months they have taken to come.
Please, my lord.
In the year 2015, my lord. And
Please, my lords, just some time is required
This-
for 1 week to comply with office objections.
retirement age is, please.
Eligible copy, sir.
Little shorter date, my lord. Reason is this. Her age is 58, my lord. She's going to retire. Everywhere they have lost case, my lord.
Sir, 7-4.
A shorter date, my lord. 1 week or 2 weeks like that, my lord.
Serial number 10, Sri Madhusudan.
Appear for the appellant's election. Seek for 1 week time to comply with the.
Shorter date,
Private respondent.
1 week or 2 weeks like that, my lord.
Twenty-three, 6,
Oblige.
11, Rajesh Kumar.
For the appellant, my lord. My lord, on the last date, my lord permitted me to hand summons on the Reserve Bank of India. This is with regarding to the matter of assignment of debt, my lord, by the lender Piramal, the asset recovery company. Yes,
11, Rajesh Kumar.
On the last date, my lord permitted me to hand summons on the Reserve Bank of India. This is with regard. Yes. Who appears for them?
I think that got repeated. I think it was his statement
But
got
it was my
echoed.
submission.
You were that. It
My
got
submission.
echoed, my lord.
Thought that someone is, no, even I thought for a moment. Yes, Mr. Ajay, tell us. My lord, we have filed a memo of service, my lord, on 10/3/25. Who is the, on whom you have served it? On the Reserve Bank of India, man. They're here in Bangalore? Bangalore, man. Bangalore. The regional office in Bangalore, the legal cell, my lord. See, their presence would be required? Yes, my lord. What do you say, Mr.
Lords, RBI will only, I think Mr. Naik, King and Patrick. Only. At least they can take it on the council.
Do one thing, not council. Who is the head of here in RBI, regional director or regional? We will issue by designation. Please, my lord. Just check up that. We will issue, and let's see in what manner the RBI has been made a party. Regional director. Regional director, na? Yes. Okay. So you have served on whom there in RBI? The legal cell, my lord. The legal cell? Legal cell. Okay. Okay. Where is the receipt, Mr. Ajay? Yes, my lord. We have filed it on 10/3, my lord. You have served a copy of the appeal also? Yes, my lord. All volumes, received all 5 volumes. Mahesh Hirama. Just say this. So you have served on the council also? Who is Aparna Mahesh Hirama? No, that is for our.
My lords, I appear for R4 to R6, man. Aparna. Piramal.
Which was
R4 to
assigned
R6.
the loan. That assigned the loan to me.
The original lender.
The assigner.
R4 to R6. R2 is the Reserve Bank. Yes, ma'am. There is the receipt for R2.
R2 is, my lord,
Okay.
yes.
Just say that despite the service, this is the court notice, no?
Not court, my
notice.
lord.
This is
And summons.
despite service having been effected on respondent number two, through hand summons. We find there is no appearance, the respondent number 2, RBI. Appropriate shall be that a notice be.
It's already issued, my lord, on
Notice is dispatched yesterday.
yesterday, my lord. 6/3/25.
Oh, further notice?
Court notice has been
Sixth.
dispatched on 6/3/25. Notice was ordered by hand summons and by court notice, my lord. So 6/3/25.
Any idea what is the name of the regional director? We'll issue by name.
I'll
Counsel in RBI.
give it to the
Standing counsel.
court officer.
Oh, but any counsel. No, let us only read it. Yes, yeah, counsel was never.
Very well. Just say that you will be able to find out.
I'll give it to the.
Just give it to the court master.
Yes, ma'am. There's one Mr. Gurumurthy, but I'll just confirm. I'll call Reserve Bank of India and I'll confirm it.
Okay. By name, what is the name? Gurumurthy,
Local director, regional director.
who is the regional director of the Reserve Bank of India. Gurumurthy,
No, no, I'll just confirm and give it to
but
the court
he
officer.
can be maybe the previous or not the
Yes,
present
yes.
incumbent.
This, Nadina, hour I will find out and
Just tell them.
I'll tell them.
Okay, otherwise we will issue notice on this name.
Please, my lord. Next hour I will.
At 10/3, this is the same place, respondent number 2, returnable on. After 2 weeks, just.
My lord, the hearing before the NCLT, my lord, that is my urgency. That's on 27th of March. Any date before that, my lord.
Have it before that. Just have it before 27th.
My lord, one more submission. On the last date, my lord, is pleased to recall, we had.
Otherwise, you know about the interpretation of that Reserve Bank
Yes,
instruction, huh?
There is
Because
one
even
Gujarat.
recently in pro knitwear, the Honorable Supreme Court has held that the directions of the Reserve Bank of India by master circular is not discretionary but mandatory. I'll place that authority also. So there's no leeway for any person functioning within the banking
Okay,
regulation.
just before 27th. Just give the name, please.
Yes, my lord, one more submission. On the last date, we had
Including,
filed.
just, no, we will say through hand summons, you will get this served by name,
Yes, my lord.
hand summons.
Yes, ma'am.
25/3.
No, no, little earlier if it's convenient to.
No, it's all right.
My lord, one more submission. IA 1 of 25 is to bring the corporate debtor as co-appellant. Learned Senior Counsel submitted on the last date. They have no objection if I recall.
That's because, my lords, they filed as directors when it was under the IBC, there was a moratorium.
Yes.
Now it's
So
been
there-
remanded.
There's
I
no
have no
order to
objection.
that effect, my lord. So we can't amend the cost
The
type.
writ petition was by the debtor,
Corporate debtor.
the original writ petition.
And thereafter.
Was he the director there?
Yes, yes. He's the director and they own the.
The
majority
directors have
share.
filed the appeal.
But the corporate debtor was a writ petitioner.
Yes, yes. Therefore, we filed IA 1 of 25.
At page
Because
45.
the
your lords.
CIRP is
Just
now
say that
over.
1 of 25.
Yes, sir.
This is an application filed by the appellant here for impleading the
Where are you? Page 6, my lord.
He's spent the Proceedings are pending before NCLT,
Yes.
not AT.
No, no,
NCLT.
AT has allowed our
NCLT
appeal.
remanded the matter back to NCLT.
See that NCLT order?
Yes, that's along with my application at, along with IA 1 of 25, page 10. The operative part is at ink page 65, my lord.
Page
65.
What did we say, ma'am? For impeding the GSTAAD hotels, just take it from page 6. As the proposed appellant number 3. Mr. Fernandez and the senior counsel appearing for.
R7, respondent
R7.
number 7.
And what about the others?
The others are who assigned the loan to me.
My lords, I appear
So
for,
you don't have any objection?
I have no objection.
Can we say contesting party?
Yes.
The contesting party has no objection for the proposed appellant or so and so to be a appellant number 3. So if that be so, comma, the application is allowed. Mr. Ajay shall file amended memo of parties. Okay, before the next date of hearing. Re-notify on the date fixed.
Lordship, I appear for respondent number 8, Lordship. It's not reflecting in the cause title, but I filed my wakalat as well.
It is not affected. Respondents are not affected, no?
And my lord, we have filed a memo for deletion of the 9th respondent, my lord, that is the insolvency resolution professional.
Oh, then now he will go. That the bar has gone, moratorium.
Yes, yes.
Now that's the reason you have come in.
Yes,
The directors had come in, my lords, instead of the original petitioner.
Now the original company has come in.
yes.
Come in, the directors can actually go out. Anyway, that doesn't.
No, no, R9.
No, he wants to remove the IRP now.
IRP, also,
Obviously.
yes. We have filed a memo, my lord. to
Let's see,
delete.
what do you say on that?
Yes.
Where is the memo? The early hearing you will not press now, you will withdraw this.
Yes, my lord, because it's fixed for,
Today, in any case, we have heard it.
yes,
And just show your memo.
19 to 25, my lord.
90?
To 25. Deletion. 19th February 25. That is, notice may be dispensed with the IRP.
It can be
Insolvency
deleted.
resolution profession.
And this IRP was at your behest. You were the applicant.
Lords, yes.
Yes.
Before this.
The asset recovery company was the,
Lords, IRP was impleaded only in the writ appeal, because by that time, my lord, the moratorium had set in. So now, my lords, he can be,
notice may be
he can
dispensed.
be deleted, or my lords, even notice can be dispensed with. He is now neither a necessary nor a proper party at this stage.
We'll file a memo to that effect during the course of the day.
Or shall we let him, ask him to come?
My lord, he is not,
Was he represented in these proceedings?
no,
No, no, only in the writ appeal he was made a party.
now he is functus officio, my lord.
I know, you're right. Just say that Mr. Agesh has drawn our attention to memo dated 19 to 2025. State that the respondent number. But you only seek dispensing with the notice,
Yes, my lord.
not the deletion.
I'll file a memo for deletion. also.
Do that.
I'll do that now, right now.
Say that he intends to file
Yeah.
a memo seeking deletion of respondent number 9, the IRP appointed by the NCLT. As the moratorium has been withdrawn, has
The order of admission has been set aside
the order
It has
of the
been-
admission has been set aside
under section 7
by the NCLT.
NCLA.
And matter remanded to NCLT for
Mr.
special.
Israel and the senior counsel does not dispute the said position Full stop. That be so, comma, memo be filed before the next date of it.
Grateful.
Then 14%.
Yes. My lord,
How much court fee you had filed?
I had paid court fee of 4.3 lakhs in one case.
And what
And
was,
similar amount in the other case.
what was the objection of the registry?
The objection of the registry states court fees to be made good as per paid in Com OS 391/2020 in trial court under section 49 of Karnataka Court Fees and Suit Valuation Act. Your Honor,
One
my-
minute. How much you had paid in the, before the court below? How much you had paid before the trial court?
I had paid 4.35 lakhs in the one case and about similar amount in another case. Your Honor, may I make
Yes,
a
one
few
minute.
submissions?
Just one.
So indeed, I
Just
am,
1 minute, please.
sure.
Just see that. Do you have the certified copy of the judgment and decree?
Yes, it is in the bundle and the page number, if I may point.
Where is the decree? Just show us, man.
There is the final judgment and order. It is page numbers, if I may. For COMAP 512, the page numbers are 62 to 93, Your Honor. And you'll notice on page 92,
Now, which is the order you are challenging?
the order I'm challenging is on page 92, Your Honor. And the operative part is the suit of the plaintiff filed against the defendants is dismissed as non-maintainable. So this is a dismissal.
Yes, one.
Okay.
See, we don't have the complete copy of the impugned order. Where is the decree?
There is no money decree, Your Honor, because the matter was,
We want to see where is the decree sheet. There must be a decree sheet attached to it.
there
Where
is
the
no decree sheet. The order, the final judgment and order,
Yes, thereafter, they must have prepared a decree sheet. which
it was
has-
not
Did you
prepared.
apply for it?
There was no decree because it was dismissed on a preliminary matter of maintainability.
That is the final order. I have checked again.
How much court fee you have paid today in this appeal?
So I have not paid because.
You have not paid.
No, because my submission is, if I may continue. So firstly, this appeal arises from a case in commercial court where I'm the plaintiff and I'm plaintiff in person. And it is for recovery of money. And I filed a suit and I paid approximately 4 or 5 lakhs in both cases. And soon after that, an additional issue, which is the suit maintainability issue, was framed by the Honorable Court, and it was framed as a preliminary issue. Hence, the suit did not proceed through evidence.
No, but still you have to file the same, deposit the same court fee.
My lords, if I may go on with my submissions, because I have arguments and I have case law as well.
Sure, the case law.
Yes, sure. It's all a part of my submission.
Very well, show us.
Yes. So there was no adjudication on merits. There was no evidence, no trial. The matter was dismissed on maintainability.
Suit has been dismissed on maintainability. So there is a finality attached to the suit. Getting the point?
Yes, Your Honor.
So nothing survives before the court below.
Yes, Your
Now,
Honor.
when you file an appeal, section 49 of the Karnataka Court Fees Act contemplates a similar court fee need to be filed in the appeal.
If I may beg to differ and submit. So if I can point to paragraph 8.
You have the copies of the judgment?
Yes, I have, and I am going to mention and highlight that in Karnataka Court Fee, section 49, what is relevant is that the fee payable in an appeal shall be the same as the fee that would be payable in the court of first instance on the subject matter of the appeal. Now, the subject matter of the appeal is not the merits or recovery of money, nor is the prayer. In fact, the Karnataka Court Fee Act goes on to explanation 4, Your Honor. It is abundantly clear. If I may have you read explanation 4, where the relief prayed for in the appeal is different from the relief prayed for or refused in the court of first instance. The fee payable in the appeal shall be the fee that will be payable in the court of first instance on the relief prayed for in the appeal. Now, if Your Honor may kindly look at my prayer in this appeal, my prayer is remand.
Read explanation 4.
Explanation 4.
We will just read it slowly.
Yes, I will. Where the relief prayed for in the appeal is different from the relief prayed for or refused in the court of first instance, the fee payable in the appeal shall be the fee that would be payable in the court of first instance on the relief prayed for in the appeal. Now, Your Honor, I may submit that the prayer in the relief is completely different from the prayer in the underlying case.
Now read it. We will read it for you once again. Where the relief prayed for in the appeal is different from the relief prayed for.
Yes.
Or refused in the court of the first instance. The fee payable in the appeal shall be the fee that would be payable in the court of first instance on the relief prayed for in the appeal.
In the appeal, that is the key word. So what is to be determined is the subject matter in the appeal and whether it is different. Similarly, what is to be determined, Your Honor, is the prayer.
Yes, one.
Is the prayer.
1 minute. How would you answer explanation one?
Yes, before I do that, Your Honor, may I point your attention to the two cases that have been attached. So if you it is a memo of two judgments. Oh, in my submission today, Your Honor, in my submission today. No, not in today's submission.
Have you filed anything today?
Yes, I have filed
Have you filed?
the two submissions right here today.
And you must keep in mind the explanation one also.
Yes, Your Honor. Would you kindly? So those are my written submissions for today. And the second part of each of them is actually a memo of two judgments. If I may have you go to page, and I have kind of folded it. If I may have you go to page 8, this is High Court, Karnataka High Court in the case of Srimati Veena versus Srimati Suma. On page 8, in paragraph 23, may I have your confirmation that we are looking at the same thing?
Yes.
Okay, in paragraph 23, somewhere in the middle of that paragraph, it states, therefore, what is the subject matter in the appeal and the subject matter before the trial court has to be taken into consideration for the purposes of computing the court fee and jurisdiction. In this regard, explanation 1 and 4 play a dominant and important role. Now, if I may now go to the next case, which is actually from Andhra High Court, Honorable Andhra High Court, where the act is similar in terms of all the wordings and the numbers. And it's a 3-page case. If I may direct your attention, Your Honor, to page 14, which is the last page. And in somewhere in the middle, it states, the only question for decision in the appeal is as to the maintainability of the claim for profits for one reason or the other. We are therefore of the opinion that the appellants need not pay ad valorem court fees in the appeal as in the trial court. Exactly because I'm not praying for any money here. I'm simply praying for a remand so that the case can be heard again. Now imagine, Your Honor, a particular situation. Imagine that I prevail in this appeal. If I may.
What is the reason for the trial court to reject, who had filed section 8? They have filed section 8?
No,
Who had filed it?
I'm sorry, Your
Why was the suit dismissed?
the suit was dismissed on the ground that it was found. Let me just read. The operative order is suit of the plaintiff filed against defendants is dismissed as not maintainable. If Your Honor is asking what was the ground of maintainability, the answer is that the question, Your Honor?
That's right.
They brought up, when Your Honors are ready. May I answer, Your Honor? May I answer that question?
Yes, one.
Please take your time.
Mr. Kumar, we will do one thing. We want to look into this court fee aspect. Okay?
Yes, Your Honor.
But then only we'll take it forward your appeal. Till such time we are clear what you are saying is right. Okay? We will also examine it.
Yes. Your
So
Honor,
we will have it next week.
Your Honor, may I make just two related submissions right
Yes.
here? It may be relevant. As to the question, in case there is that question, what was the ground of the issue of?
We have seen that. That we have seen.
Okay, so the important fact is now, the statute as well as the case law is clear that what matters is the subject
We will
matter
see, we will
and the
see.
prayer
We will see.
in the appeal, and they are both completely different.
Okay.
Now here's the important and interesting point. Imagine, Your Honor, if, let's say, whatever the court fee ordered is, let's say I pay that. Let's say further that I prevail in the appeal. Of course, the appeal is simply asking for a remand.
No, we have got your point.
No.
What you want to convey, we got it.
There's a slightly related point.
Yes.
If I prevail, and then imagine if there is a need to appeal again, then I would be having to pay twice. That cannot be the spirit of this court and this
Yes.
country.
Yes, we will. That's the reason we want to see ourselves also this. Okay?
Much obliged, Your Honor.
Just say this, the office has raised the objection of non-deposit of the court fee in both the appeals. The appellant who appears in person would submit that the subject matter of the appeals is primarily dismissal of the suit on a preliminary issue. Preliminary issue on the ground that there is an arbitration clause which governs the parties. Full stop. The
It's a maintainability issue.
just say this, which was dismissed on the ground of maintainability. Don't say section 8. On the ground of maintainability. Full stop. The appellant relies upon explanation 1 and 4 of section 49 of the Karnataka Court Fees Act. Karnataka Court Fees Suit Valuation Act 1958. It is his submission that the subject matter of the suit, the subject matter of the appeal is different from the subject matter of the suit, and hence he is not liable to pay the court fee as was deposited before the court below.
Your Honor, the prayer also is different.
He relies upon 2 judgments in support of his contention. In the case of so and so, so and so. Just take this. Huh? Full stop. Just we deem it, in noting the said submission, comma, we deem it appropriate to re-notify this appeal next week, just give it.
27/3.
27th of March.
Much obliged, Your
Come.
Honor. Thank you.
Okay. Thank you.
My submissions have gone. Much obliged.
He has filed, just say also additionally, he has also filed written submissions. The same are taken on record.
And everything is mutatis mutandis for the other,
Where is that? In the other also file it, please. Just take that.
this is for 513, everything mutatis mutandis.
Yes.
Much obliged, Your Honor.
Let's keep it in the other one. Next.
14. Three Rashtrika.
You appear for whom?
For the respondent, my lords.
Who is the appellant?
Lords, twice the matter is listed, my lords. They took time, lords.
You are the appellant?
No, my lord. He's the respondent. He comes.
You are the respondent. See, there is an issue of maintainability. here.
Yes, my lords.
Just show us the last order.
Your Lordships.
Yes.
Serial number 14, Your Lordship. Serial number 14, where Your Lordship, a short explanation will be given, Your Lordship. We have engaged a senior counsel for the purpose.
Ma'am, we are dismissing this.
Please, Your
Last time we have taken adjournment. They taken adjournment.
Lordship, Your Lordship,
We will dismiss this.
Your Lordship, kindly.
We'll just pass over. Whosoever wants to argue, please argue. This appeal apparently appears to be not maintainable.
Kindly
Pass over.
15. Total.
Let fresh notice be issued. Who appears for respondents 2 and 3?
I appear for the respondent. Matter was listed yesterday. It was heard for some time and
We heard it.
it's a matter, my lord, wherein I'm seeking promotion since
Okay, let's-
2010.
You appear now, ma'am. What is your case? See, the National Medical Council commission has come. They say we will not disturb what has been done by the MCI. And the MCI regulation prescribe post-graduation in biophysics as an eligibility. So it must follow.
My senior will give instruction for my son.
We'll dismiss it. It was listed yesterday with an understanding it will be argued today. That's right. We'll hear it. We'll just pass over, just call the council. And we will take it up before lunch.
Please.
16. Srimati Vidyalata.
And what are your instructions?
Just
One table is filed, my lord, it's served on us.
That's if your Lordship would kindly go to page 25 of the.
Ma'am, tell us one thing. You still think that 10,000 was a wrong fixation?
It's not wrong. It's
Huh?
correct, it's correct fixation.
It's
There
an
is no
incorrect,
wrong-
it's a correct fixation.
Yes. If there is no wrong fixation. Can you see page 25, my lords?
Hmm.
My lords, four lines from the last. The
Mhm.
Lordships gets 8,200.
8,000,
200.
that's right.
My lords, this was on 1/7/2009 in the state pay. Correspondingly, my lords, respondent number 13, Natraju got 9050 in the state pay.
That is 110/2008.
I would request my learned friend not to
Mr.
interrupt, but
Prabhu.
if he wants to argue,
Will
I
not-
will.
Yes, it's all
This
right,
is
ma'am.
so much, my lords, I had
The
to.
court has expressed itself.
No, I'm sorry.
And yes, it's
Request.
all right. Don't take it further.
Good friend. of-
Next,
So,
tell us.
8,200 and it was 9050 as on 1/7/2009. Why this date is important, my lords, was this was the date when they both were promoted as assistant court officers. All of them.
On 1/7/2009.
On 1/8/2009. 1/8/2009, they were promoted as assistant. The next, the beloved.
The next one, yes.
So, my lords, the difference what they got, my lords, was 8,200 to 10,000 in the state pay. Because 10,000 was the lowest of the pay scale of a assistant court officer.
That's right.
Here, this person got unlucky. It was 9050, so he did not get any increment on promotion because 10,000 was the lowest. So
He could not have got.
he could not have got anything more. So, my lords, the difference was 8,200 and 9,050. My lords, both got 10,000. That is what happened in the state pay.
No, on what date
Yes, my lord.
we are looking at the disparity has
We
come?
are looking, my lords, on 1/10/2004. Your lordships would go back to the first column. Kindly see, my lords, even on that day, the state pay was 3,550. And here it was 4,250.
That's right.
My lords, can I request your lordships as to how the pay is fixed? If your lordships could kindly go to page 16, my lords. Happens in the fixation. Your lordships got illustration number 1, my lords. Fixation of initial pay in the revised pay structure. Existing scale of pay was whatever. My lords, the third serial number is 4,800. My lords, for all pay fixation in the revision, my lords, we look at what was the existing pay on that date. So here, when we started the revision itself, there was a difference. So the scale of pay for the central rules, my lords, was very much different. Now, my lords, can I request your lordships to go back to page, I'm sorry for taking your lordships back and forth. It is page 25, the second serial number, my lords. That is 6/10/2004. If your lordships could get 6/10/2004. Kindly see, my lords, in the central, my lords, your lordships must remember, the central pay scale, my lords, the central pay rules are very much different than the state pay rules. Kindly see, my lords, on 6/10/2004, the state pay, my lords, was 3,550. Correspondingly, my lords, his was 4,250. Your lordships got the second column, my lords. Your lordships got the second column. Second.
Yes,
3,550, 4,250.
that's right.
My lords.
Similarly, 3,650, 4,350.
There is no dispute there. Kindly see, my lords, what happened on the first central pay when we brought in. It was, for all of them, it was, the scale was 4,000 to 6,000. But here, the corresponding was 5,500 to 9,000.
But
What is the difference?
tell us one thing. You promoted both of them on 1/8/2009 as ACO.
Yes, my lord.
Okay. You can possibly argue
Yes, my lord.
and that even under the state scale,
Yes, my lord.
there was a difference in the basic pay
There was a difference.
in both the cases.
So the
So when they were promoted, the fixation was at 10,000.
yes, sir.
That's the minimum of the pay scale. So you are fixing that. See, one is grant of the minimum pay scale. When you grant 10,000, you will grant minimum of the pay scale to all in ACO
Yes,
on that particular day.
yes.
But which is different from pay fixation.
Pay fixation, but here no pay fixation happened because he had not reached the minimum of the promoted scale. So it was fixed at 10,000. That was a problem for him. In
In whose case?
In both of them. Though the difference was 8,200 and 9,050, both had not reached.
But
the
what is this? What is this 15260 and 17540?
I'm sorry, where am
The last, if you see the third column from the left side,
15260, my lords, is the central pay fixation.
So today effectively,
Yes, my lord.
you will proceed on the premise
Yes, my lord.
that on 1/8/2009, when they were promoted as
Yes.
ACU,
Yes,
they have to be given the central pay.
yes.
Though it relates back to that
2004.
6/10/2004, but when they were promoted as ACO,
Yes.
in any case, possibly Mr. Prabhu would not dispute anything which had happened before 1/8/2009.
No,
He
didn't.
was all throughout drawing higher.
He-
His contention is,
Lesser.
no, he was drawing lesser, the other gentleman is
Yes,
drawing.
yes.
His contention is only on 1/8/2009.
9 in the stage pay.
Yes, right. So when a person is promoted
Yes.
from the feeder cadre to the promotion post, you will see what is the minimum of the pay scale. Let's central pay scale say hypothetically 10,000 - 15,000.
Yes, my lord.
The fixation would be at 10,000
10,000.
and then fixation would take place. When you fix the pay, in fact, we are going to, Mr. Prabhu, you have to respond to this also. When you are fixing the pay at 10,000, they will be fixing the pay at 10,000. They will take into consideration what was the actual pay you were drawing in the earlier, a day before.
Yes.
Okay, then they will fix it.
Yes.
The basis for pay fixation is 10,000,
Yes.
subject to what you were drawing.
Yes.
In the earlier, before that date,
Yes.
both were drawing different pay.
Yes.
Okay, one was drawing higher, the other one drawing lesser.
Yes.
A person who is drawing higher would be the foundation for the pay fixation at 10,000. You getting the point? Would be the basis for fixation at 10,000. You are representing, his pay was lesser than the person to whom you are seeking parity. So he was drawing more and you are drawing less. So that being the basis, that difference would continue even pay fixation at 10,000. You're getting the point? I hope we are clear. The difference
Notionally.
as existed one day before
Yes.
would continue to be reflected, continue to have the effect
Bearing.
even on a fixation at 10,000.
Well, I would say, my lord, that 10,000, whether it is on the basis of, I bow down to what your lordship said.
Just
90
only one point.
Sorry.
10,000 is not a fixation. 10,000 is the scale, minimum of the pay scale. See, that's what they say. If you see the last column,
Yes.
state pay, then they say 15,260, in which scale they are putting 9,300, 3,400. And interestingly,
Yes.
if you see the right-hand column, the third column from the right side,
Yes.
he is also fixed in 9,300, 34,000, 8,000.
Yes.
Grade pay is 4,600, grade pay is 4,600.
Ah.
But what makes 15,260 is
Versus.
14420, just immediately above.
Please.
But whereas the person, this gentleman, what is his name? Natraja.
Natraj.
He was drawing 16640. So that reflection is there on 1/8/2009. That's what you want to convey.
Yes.
Yes. Yeah, my lord. Now, my lord, it is a, kindly see the next page also, my lord, 26. Now here, also your lordships will see up to, my lord, the promotion as CO, there is one point, my lord, I forgot to mention and press to service last time. Our batch, the entire 1 to 13, all of us, Umashankar, when I say Umashankar, my lord, I mean all of them, 1 to 13, and other court officers similarly placed. All of them were promoted as court officers on 15/4/2013. Lordships will see that middle column, my lord, on 26. And we were drawing 22,800 as per the state pay scale. Now, whereas, my lord, this respondent number 13 was promoted as court officer on 13/3/2014. Your lordships may see 15/4/13 is our date and his date is 13/3/2014. This is one pertinent aspect, my lord, I'm bringing to your lordship's notice, that my promotion or our promotion rather is 1 year prior to his promotion. That is one aspect. And secondly, my respectful submission is, my lord, that whether that 10,000, the yardstick for fixing 10,000, pointedly answering Lord what your Lordship said at page 25, Lordships Lord pointedly asked me that it was not a pay fixation in stricto sensu.
Yes.
It was a comparatively, it was in juxtaposition to the earlier salary drawn by the highest person.
And that 10,000 is the
Became the
minimum of pay
basis.
scale.
Sorry.
Minimum of the pay, 10,000 is
yes.
minimum of the pay scale.
Now, my lord, for all practical purposes, Lordships asked my lord on the last occasion whether this 10,000 could be varied or is there any?
After seeing this,
Yes, my lord.
and after seeing this, the pay and what she has also said, the pay scale was starting from 10,000 something.
Yes.
Yes.
That's the pay scale. But fixation is different and pay scale is different. Minimum of the pay scale is different from the fixation. Fixation is at what actually you will be drawing as a basic.
Yes.
But basic fixed in a particular pay scale, that 10,000-15,000.
Yes. Yes.
That's how it should be.
Now, even if that is taken, my lord, 18,000, now kindly see, my lord, the writ petition, writ appeal copy 164. Here also 10,000 with effect from 1A to page 164, my lord. In case of Nataraj, 10,000 plus so-and-so in the pay scale of 22,800, 43,200. And this one also is, my lord, the same.
This is
Which
nothing but.
which page?
164, that pay fixed as per Karnataka, this one, my lord, at column number 3 of Nataraja is 10,000 plus 1,018, 2009 in the pay scale of so and so, what they say. And in case of Uma Shankar, next page, it is also, my lord, the pay fixed as per Karnataka pay scale with effect from so and so in the pay scale of 10,000, 18,150 is what. Why this 22,800 and 43,200 is shown, and in my case it is 10,000, 1,850. I mean, it is, my lord, for all practical purposes, whether it was pay fixation or a pay scale or whatever, that is the amount we both draw.
Show you.
Yes.
You see the next page 165.
Yes.
Call the serial number 3.
Yes.
Promoted as assistant court officer.
Yes.
10,000 with effect from this.
Yes.
Pay scale of 10,000, 18150. So 10,000 is the minimum. So
yes,
they will do it. And this is only a scale. What they are reflecting is, look here, this is the minimum of the pay scale. The fixation would be depending upon what you are drawing. You know, there are formulas. What you would be drawing there. Then they will fix it at 10,000. So 10,000 for you, 10,000 for him.
Yes.
Depending upon the previous pay you are drawing.
Yes.
Whosoever is drawing, because that will get reflected at the time of fixation on promotion.
Yes.
That's how it will happen.
In fact, my lord, we have drawn the example of, this is only, he is not an adversary, my lord. As such, we have not arrayed him. This is only as an illustration we are showing. There are few more employees who are getting higher pay than them. In fact, my lord, I had filed an application, RTI application also, which was rejected, and I have filed that application here.
In that sense, it's not adversarial.
Adversarial. There is one or two more employees who are drawing more than this Nataraja also.
The concept is this.
Yes.
A junior should not draw more than a
principle.
senior.
Yes.
That's the concept.
In principle is that. Now, ultimately, my lord, my other final argument is that, my lord, if there is functional parity, as soon as we reach ACO phase, if there is functional parity, for whatever technical reason, whether for pay scale, that my lord, those nuances, I do not want to get into. I am saying, as long as there is a functional parity in the job description, the actual work, and my lord, the ACO being the feeder cadre for CO is also same. And when we are promoted as court officers, we were promoted much earlier than the other batch, the other two. Say one Savita Erumal and also, my lord, this person. So these are the crucial factors wherein, my lord, for the same work, there is a disparity for whatever reason.
Right. But that concept would not come. As long as they are fixing you in the pay scale. Pay scale, they are not. Pay scale is not different. 10,000, 18,500 is all everyone is getting. That's the scale attached to that ACO.
Yes.
So no one is being denied that. Everyone is fixing.
Yes.
It's only the fixation varying. Fixation is getting varied because of the earlier high amount which you are drawing. That's the basis.
The earlier, my lord, both of us were getting less than 10,000 only. There is no dispute.
See, fixation is in 10,000, 18,000. But what would be a pay? The pay scale is 10,000, 18,150.
Yes.
The fixation is based on what you are drawing in the earlier day when you were actually given promotion on 1/8/2009.
Please.
So that will have a bearing. That will have a bearing. Otherwise, the Mr. Nagaraj, the gentleman would be say, Nagaraja would say,
yes,
look here, I was drawing a higher pay.
Yes.
How did you remove that disparity when I'm continuing to drawing a higher pay qua the other gentleman? That difference must continue to exist and I must continue to draw a higher pay. You can't remove the disparity.
My lord, just before promotion,
Yes.
just before, my lord, he was promoted as ACO, Nataraja was drawing, my lord, 9,050 and I was drawing 8,200. My lord, the page that,
20.
yes, 25.
Which page?
So
which page?
page 25, my lord, of the document that is, my lord.
Fourth line from below.
Now, but kindly see, my lord, kindly see, my lord, the date variation. That is what I wanted to point out at the very outset. This was 8,200 was my salary as on 1/7/2009, whereas, my lord, this was 9050 was 110 as on 1/10/2008. Those dates are not matching.
Much earlier.
Hmm.
Dates are not matching. Even
Hmm.
from then till from
Correct.
1/10/2008.
I am not asking for equality from the previous phase. The moment I am promoted as ACO, when both of us were drawing the same salary, from that phase, my lord, I am asking. Whatever happened prior to that, my lord, is another story. I am not asking, claiming anything qua that period. Only the period from which there was a pay parity for whatever reason. For 10,000 was the pay parity as on the date we were promoted as
If we were to
ACOs.
put it,
Yes.
so on 1/7/2009
Yes.
or 1/6/2008.
Yes. 1/6/2008.
1/6/2008.
Yes.
You were drawing
7625.
7625.
Correct.
He was drawing 9050.
No, that date your lordships may see. That was 1/10/2008.
Right.
4 months, it's a
Well, in the same Allah.
Well,
But
Okay,
1/10/2008, my salary also, my lord, was
No, your salary was on 1/7/2009, it became 8,200.
Huh.
From
Let it be.
1/6/2008 to 1/7.
Mr. Raghu or Mr. Prabhu,
yes,
just go just one step above.
yes,
1/6/2007, you were drawing 7450.
yes,
On 1/10/2007, he was drawing 8825. That's right.
yes, 1/10/2007.
Okay.
Yes,
Now let's assume for a moment
yes,
that on 1/6/2008, let's
Yes.
take your date.
yes,
You were drawing 7625.
yes,
He was drawing 8825.
yes.
Obviously.
Please. Yes, yes.
He is drawing 8825 even on 1/6/2008. You were drawing only 7625.
Yes. Please.
So on a given date,
Yes.
he was drawing more than you.
That, my lord, is prior to my becoming ACO. That is in the earlier cadre. That, my lord, is another story altogether.
We are on that only. You are right. You have used the appropriate word. That's in the earlier cadre. The effect of the earlier cadre will be felt when you are fixing in the next promotion post.
Yes, if that is so, my lord, I question myself, then as ACOs, when both of us were, my lord, equated on the same. Now, the Nataraja and other person knew well that they will be getting the same pay as us. Or I knew that I was getting the same salary as them. So the pay parity as it existed when we were in ACO is all that we are asking.
The answer is when you are saying pay parity means
scale of pay?
9300-34800 with the grade pay of 4,600. That is where they have fixed you, and that is where they have fixed the respondent number 13 on the right-hand column, third
Yes.
column. So that remains identical. There is no disparity qua that.
Up to ACO.
Up to ACO, even thereafter.
No, even after that, my lord, it became 10,000. After that, my lord, the last column, it 10,000, 10,000.
26, my lords.
On the same page, your lordships may see the 10,000, 10,000 parity, my lord, was achieved as on 1/8/2009.
See, this is I think we should not say misnomer. This 10,000 reflects what is the minimum of the scale when you have been promoted as ACO. ACO scale is 10,000, 18150. That you will get it from the writ petition, page 165.
Please.
So you're getting the 10,000.
10,000
dash 18150.
Yes, my lord.
That's the scale.
Correct.
But there has to be, within the scale, there has to be a fixation. That fixation means that fixation would take the color from earlier pay the officers were drawing. So that's the reason they fix you at 153,260.
Yes.
And him 17540.
I'm sorry. I'm
Okay. Yeah, right. We'll put it another way.
Yes.
On 1/7/2009, your fixation was 14420.
Yes.
Page 25.
Yes.
14420.
Yes.
Under central pay.
Sorry. Yes.
You got it?
Yes.
He's 16640.
Yes.
There is a difference. There is a difference.
Yes.
When they fix it at ACO, this difference will continue. That's what we want to convey.
But had the state scale continued, my lord, the salary would have been the same, my lord.
No, then also it would be different. That they have not reflected.
It would have been dated.
It would be different.
But lordships may see, my lord, next page, the state pay scales they have compared. Say from the next page, 1/8/2010, my salary 10250 and next 1,500, 10,500, 10,500, 21,000. 21,000. All, my lord, 21,000. So state pay scale also.
How do you answer?
Fixation of the pay scales. Kindly see, my lords, column number, the second column. So we started, my lords, refixation from 6/10/2004. So the scales are very different. And the mode of fixation is also different. We give increment, annual increment is given. So everything is different, my lords. Kindly see, my lords, column number, second column, page 25, my lords. Just the.
But
page.
tell us, ma'am.
Yes,
No,
my
are you?
lords, take your lordship's there. Page 25, my lords, second. My lords, first one was the scale where we started, my lords, for both of them was itself different. Theirs was 4,000 to 6,000. For Nataraja, it was 5,500 to 9,000. So the initial scale, what they started, my lords, on 6/10/2004, that itself was different. So when we come down, my lords, when they were promoted as ACO, though the scale was same, there was difference here. The difference here, it's reflected, my lords. Can your lordships look into 1 to 3rd line from below, my lords? It was 15,260 for them. For him, it is 17,540 because the scale was different.
Even at the state pay, both were drawing different pays.
Yes, at that time.
At that time.
But the fixation, my lords, now it is refixed. Even the scale of pay varies.
Under central pay.
Under the central pay. Because we have three, the fifth 6th and the 7th pay commission. We have to do from 2004. So all the three pay commissions we have incorporated, my lords. So the scale itself changes. So this 5,500 to 9,000, he achieved only in the year 2006, which I got in the year 2000, sorry, I would not say which Nataraja got in the year 2004. Because both of them, I appear for the High Court, both of them are equal for me. So 5,500 to 9,000
Then
was.
tell us one thing, ma'am. See, ultimately what the learner single judge holds.
My lords, why am I deceived by this? May I read this, my lords? Why
You will
we are
convey it the same thing, whatever is your, the whole
just-
understanding.
If your lordships would make a little correction in the. What parity they are seeking under the state payment odds was not there in the central pay. It cannot also.
She's absolutely right. And
See, their case, if you see page 26,
Yes, ma'am.
the pay fixation on 1/7/2013,
Yes, my lords.
after they were promoted,
Yes, my lord.
is 22,800. He was not promoted.
Yes,
So he
yes,
was 222,000.
yes,
Hmm.
yes,
The state government.
yes, ma'am.
Now, but when it comes to the central fixation,
Yes, ma'am.
they got 17920 only. He got 19760.
Yes, my lords. Because it
See, that's,
continued.
that
my
is
lords.
what they're pinching.
It is continued, my lords. My lords, he was a stenographer by way of some additional examination from 2003 to 2008, my lords. We cannot forget that. 3 to 2008, my lords, this is 5 years of pay, which he is entitled to higher.
So what you are saying is that because of this change from state pay to the central pay, this disparity has occurred.
Because, my lords, we had to redo from 2004. In 2014, my lords, now what happened, my lords? The entire scale of pay was changed. The mode of fixation changed. Increments given were changed. Everything changed. So we did not do any discrepancy in the scale. We put them in the scale, same scale. But because, my lords, in this instant case, if in the state pay, instead of 9050, if he had attained 1025, which was just 75 rupees, he would have got more, my lords. Because
Now,
was just
we have
8,000.
another query. Now it's struck us. When they got promotion higher,
Yes, my lords.
the seniority will vary.
Yes, my lords. That increment is being given to them in the central pay.
No.
That has been taken into consideration, my lords, in the central pay.
No, what we are saying is on when they got promoted on 15/4/2013 as CO,
Yes, my lords.
they became senior
Yes, my
to
lords.
Nataraja.
Yes, my lords.
Now, if you have drawn the seniority list, he will be they would be senior.
Yes, yes.
Now, once a senior, they became senior, can a junior draw a higher?
That is exactly, I requested your lordships to go to page 21, my lords. This was, these were the circulars that were issued, which we have adopted in toto, my lords. Kindly see, my lords, page 21. They have told us, my lords, this was an official memorandum, my lords. They said, what is the anomaly, my lords? Your lordships gets it at page 20. Your lordships got page 20.
Yes, stepping
Serial
up.
number 2, sub number 1. In order to remove the anomaly of a government servant promoted or appointed to a higher post on or after 1/1/2016, drawing lower pay in that post than another government servant junior to him in the lower grade and promoted or appointed subsequently to another identical post, the pay of the senior government servant in the higher post should be stepped up to a figure equal to the pay as fixed for the junior government servant in that higher post. The stepping up should be done with effect from the date of promotion or appointment of the junior government servant and will be subject to the following conditions, namely, could I request your lordships to the next page, my lords? Serial number 3. E, my lords. Sorry, D. If a senior joins the higher post later than the junior for whatsoever reason, whereby he starts drawing less pay than the junior, in such cases, senior cannot claim stepping up on a pay at par with that of the junior. That's what has happened here, my lords, because the fixation was from 2004. My lords, if the fixation was from 2018, all this would not have happened. We had to do, my lords, from 2004. So the 5th pay commission, 6th pay commission, the 7th pay commission had we looked into. The fixation was different. And next, my lords, where a junior gets more paid due to additional increments earned on acquiring higher qualification. My lords, during when he was promoted as a stenographer, he had acquired an additional qualification, and that is why he was promoted as a stenographer. That reflects. Now, if we change, my lords, this change, my lords, is not only with this there, my lords, because the mode of fixation is very different in the central pay. My lords, in order to demonstrate what we have done, kindly see page 20 task that was undertaken, my lords. Kindly see page 24, which is
this is, I think, after the Supreme Court order,
yes,
where
yes.
they say all judicial officers, all the courts should be given central pay scale.
Yes, my lords, that's what happened. And our courts also adopted, my lords. My lords, with reference to the subject cited above, this is just to show what we did, my lords. It is brought to your kind attention that the team consisting of serving officers and retired officers, officials, were deputed to the extent their guidance and assistance in preparations of the fitment tables and guidance. The team had discussions with the High Court employees representatives for necessary requirement of materials of rules and regulations in existence on various aspects of fitment and provided assistance. The team could formulate the fitment tables and guided on the issues of the alliances, etc., as may be applicable under the rules governed and running at present. The guidance in the preparation of the draft fitment table and suggestions in the aspect of alliances is completed and scrutinized to the best of the knowledge in the rules and regulations. Further, any clarifications which may be sought for competent authority, also finance department.
But tell us, ma'am, one thing, why don't you communicate everything to them?
We have, that was what was challenged and which is quashed by this honorable court.
Very well. Now,
Initially,
your understanding would be what the learned single judge has said.
I would do that. My lords, kindly see page 38, my lords, the order of the learned single judge, where we are aggrieved, really aggrieved, is because he comes to a conclusion that there is an anomaly. If he leaves it to the Honorable Chief Justice or to the department to take a decision, my lords, that is different. Kindly see, my lords. Page 38 is the, my lords, what is dealt with by the learned single judge is equal work, equal pay, my lords. That is subject to reasonable classification, my lords. Article 14, Article 16. Everything would apply to equal.
But but the direction is to set anomaly right in accordance with.
So that's the problem. I don't, if there is an anomaly.
No, then it's like this now, Mr. Prabhu.
Yes.
So you will do it, remove the anomaly.
Yes.
Although it says in accordance with law, her submission is the rules doesn't permit the anomaly in the given facts can be rectified.
I'll, my lord, pointedly answer that. First is, my lord, kindly see, this was passed by His Lordship, the Chief Justice himself, this order, my lord. It is passed in terms of Rule 6B at page 29. Page 29 is the rule quoted, the Karnataka rule. I'm reading the impugned order, my lord. 6B, consequent upon adoption of the central pay scale and fixation of pay to the officers and officials of the High Court of Karnataka, anomaly, if shall be cured after obtaining necessary orders from the Honorable Chief Justice, High Court of Karnataka. Now, my lord, further I am reading, in terms of 6B, employees of the court are entitled to seek curing of anomaly from the hands of Honorable Chief Justice. Therefore, representation was submitted, and it goes on. Now, my lord, she is absolutely right in saying that in the state pay scale, I read, my lord, page 27, there was absolute uniformity, pay uniformity or pay parity. With the adoption of the central pay scale, there arose an anomaly, rightly or wrongly, justifiably or unjustifiably. Now, I'm sorry, my lord, I will complete myself.
That's all.
I am saying, my lord, that if such anomaly arises, if the state pay scale continued, there wouldn't have been this situation at all. And the situation pragmatically used. It is said disparity arises. If disparity arises, then after obtaining the approval of the Honorable Chief Justice, that will be cured, is what the rule says. Now, my lord, this is invoked, and Honorable Chief Justice says, yes, there is an anomaly, please cure it. There ends the matter.
That's the submission.
Yes.
What is being said is,
yes,
when they have shifted from, one regime to the other.
Yes.
When they are shifted to the central pay scales.
Yes.
Under the rules, there is a particular fitment formula. Now, just one.
Yes.
Insofar as that gentleman is concerned, when he got promoted to stenographer.
Yes.
Based on that fitment formula, the pay has been fixed.
Yes.
Which brought about the difference.
May I answer that?
Yes. And that difference continued. So it is something which is inbuilt in the rules that a pay fixation need to be in this manner.
Yes.
Because of which the anomaly, you may call it, or the difference in pay would come.
Yes. I'm answering it in two manners. One is, there is nothing specifically indicating that the central pay scale disparity, the cause of disparity due to adoption of central pay scale is due to his passing of some examinations, etc., is one submission. Now, alternative submission is, even presuming it to be true, my lord, I question myself, why did the state pay scale did not address this issue at all? For whatever reason. It is, my lord, treating both of us as equals.
Yeah, for the simple reason.
Yes.
According to her, the state doesn't have that fitment formula.
That fitment formula. Now, my lord, for some reason, if the central pay scale has it, and if, my lord, on account of this paradigm shift from state pay scale to central pay scale, if there is an increase, please match it, is what we are saying. Now, I am not questioning the rationale behind the central pay scale, nor am I saying, my lord, that fixation in state pay scale is more justified than the one in the central pay scale. I am not saying anything. On a simpliciter plea that, my lord, if you adopt central pay scale, there is some anomaly, this way or that way, increase or decrease, please bridge it, is what we are saying. And, my lord, if that is taken, the competitive examination or stenography examination is taken, then my promotion as court officer much prior to him also is another factor. I am not entering into a debate at all on that question. And I am also not asking the anomaly to be cured from a prior date. I am only saying after we became at par, we came at par as ACOs, is what I am asking. From that period only,
we had asked actually the same question.
Same question, Malad.
Once you became, everyone became the court officer.
Please.
You became early. Your fixation was earlier on the higher pay scale.
Please.
You started drawing more.
Yes.
Effectively more.
Yes.
Than you.
Yes.
Than the
respondent number 13.
But what happened? That was under the state scale.
Yes.
But no prejudice insofar you are concerned.
Yes.
You are drawing more. But once they shifted to the central pay.
Yes.
Because of the fixation factor and the central pay, everything got changed.
And that is what, my lord, is sought to be cured. That is the antidote. 6B is the antidote for that situation. It doesn't say, my lord.
We are putting it to you.
Please.
For that, we have to come to a conclusion. You are entitled to the benefit of the same fixation which was given to the gentleman Nataraja. Now you have to ask it.
Yes.
Their answer is Nataraja got promoted to the stenographer while you were working as typist. And hence that fixation cannot be given to you.
May I answer that, my lord? In the central pay scale, let my learned friend show, a particular provision or, my lord, some methodology, some formula, which says this pay parity is on account of that. If, my lord, in state pay scale, there exists none. These are, my lord, our own supplementing the logic. Now, in the state pay scale, if he was promoted, then now, my lord, now I am asking myself, if the state pay scale continued, whether he had passed the examination or not, he would have got the same pay scale.
Okay.
They wouldn't have changed this pay scale at all.
We will show that.
Page
I-
16, my lords. Page 16, my lords. What is
16.
taken into consideration as on the day we fix the salary, my lords, sorry, we refix, my lords, is the basic pay existing on 1/1/2006. 1/1/2006, there was a difference, is what I'm trying to
Under
tell.
the-
Page 16.
Under the central scale.
Page 3, illustration, fixation of initial pay. When we
That-
started, there is a difference. We cannot wipe out, iron out the difference. If we do this, my lords, there are thousands of people. We
We'll
can't.
have
Yes,
a
thousands are
huge-
working.
My lords, kindly see.
Is that the basis?
On a lighter note, they had an option to come to this or not. They could have said, we will
No,
stay
this
back in the
is-
state pay. We have taken that option that we
Oh,
will.
they had an option?
Yes, yes. Under
No, where is the
page 50,
No.
they had an option.
Yeah.
They've come with an option. They were given an option.
And mind it, Mr. Prabhu,
Yes.
when you got promoted to CO, you were given fixation under the central pay rules.
Yes.
You got a higher fixation which you would not have got it under the state. We will tell you.
No, that all of us got. Nataraj also got.
So the benefit which he got
Yes.
when he was promoted as stenographer, you got when you were promoted as CO, pay fixation was under the central pay.
No, first of
What
all,
is
my
his
lord, my
submission?
instructions are,
Forward, what is his submission?
yeah, my instructions are, my lord, that there was no option given. That
Further.
migration to central,
Let's
I stand
further-
correct.
let's
One,
further.
one. Secondly, my lord, this what my learned friend just now read is the central rules, which according to them is the basis for the disparity for whatever reason, my lord, whether for competitive examination or his early promotion or whatever it is. All that I am submitting is consequent to adoption, if there is a disparity or anomaly or a difference, I would even, my lord, put it in a simpliciter manner, not attaching any importance to it. If there is a difference, please bridge it, is what I am saying. What the rule is saying, I'm sorry, what the rule is saying. And, my lord, the learned single judge exercises that jurisdiction as Honorable Chief Justice, as a single judge hearing the matter on judicial side. Now, my lord, can that be found? It's a discretionary order. Now, my lord, the Honorable Chief Justice says, yes, there is a discretion vested in the Honorable Chief Justice to cure that anomaly. I exercise that option. I direct the registry to exercising my discretion. I found, sorry.
You will satisfy us.
Yes.
In the facts where there is a fixation formula is different under the state and the central.
Yes.
This anomaly can be rectified. Show us in law. See, we'll tell you, let's see.
Please.
Any fixation, you have rules, you know, FR 22, 1A1, so many rules are there.
Yes.
The fixation has to be done. Interestingly, every eventuality is contemplated for pay fixation. If you are getting promoted, there is a particular fixation.
Yes.
If you are coming on deputation, there is a particular fixation.
Please.
If fixation is on the basis of the rules, possibly those are missing. Going by what submission she is making, it appears those fixation formulas were not applicable, were not available under the state government.
It was not. The increments, the annual.
So
increments.
that fixation and the fact remains, there is a shift from state to the central. And because of this shift, everything has come like this.
Please. And the 6B is an antidote to that situation.
You
I
tell
am
us.
saying, my lord.
You tell us.
Yes.
That's the reason we are posing a query.
Please.
Given the fixation being different under the central pay and state pay, this anomaly can be cured. You answer it in law.
In fact, my lord, I'm given one document. I have only one set of it. Says the conditions of service. I am reading, my lord, this is the High Court of Karnataka, Conditions of Service of Recruitment Rules 1973. I'll pass it on, my lord, with copies. Read it and give it to my other side also. Says in respect of all such matters regarding conditions of service of the members of the High Court service for which no provision or insufficient provision has been made in these rules, the rules and orders for the time being in force and applicable to the servants holding the post of Government of Karnataka shall regulate the conditions of service of the members of the High Court, subject to such modifications, variations, exceptions, if any. So, my lord, I am saying under the state rules, my lord, if there is no rationale, no logic given for these promotional matters, etc., whether that system is correct, whether that paradigm is correct, or this philosophy is correct, not is another issue. If we had continued under that regime, for whatever reason, there wouldn't have been this situation at all.
They can opt out.
Now, my lord, it is easy to say, no, opt out, Allah. How can, no, my lord, there is no option. It is not voluntary. Now, if she says, my lord, that it, in fact, it was voluntary for Mr. Nataraja not to opt as an ACO. He would have gone under his own cadre and
See, the
opted
only
something
thing,
else.
if you see the direction at page 38,
Yes.
if you agree, the matter is remitted to the first respondent to reconsider the case of the petitioners
and set
the anomaly right in accordance with law. If you don't insist upon that matter is remitted back to the respondent to reconsider the case of the petitioners and to convey to you their decision. It can be either way.
It is, my lord, it will repeat, the history will repeat, my lord. I bow down to say, because my learned friend now itself, she is conclusively coming to a conclusion.
Kindly see annexure.
She's already concluded that, my lord, the central pay scale, there is some rationale, some justification in adopt.
We will say so 5.
Yes.
If they give you reasons, you can look into those reasons. If you are not satisfied, you have a right to challenge it. Today, you're getting the point.
No, but it will only repeat, my lord. With folded hands, I'm saying, this will again, she also knows, my learned friend also knows, it will again be a futile exercise.
That's the reason we are putting it to you.
Yes, my lord.
You will satisfy us in law.
Yes, my lord.
When there is a fitment, and you must look into it, what she's saying. There was no fitment formula under the state government, but there was a fitment under the central government. So because of this fitment formula, this change has come about, this disparity has come about. If you feel otherwise, if you say that there was the same fitment formula in the state government, still this disparity has come, it need to be cured. Possibly we will look into that argument. We will leave that open. You want to look into it. So that's the reason.
I will leave it. I leave it to your lordships, my lord. I will examine that, my lord. I bow down. But at the same time, my lord, I'm at the cost of repetition, I'm saying, even if that is so, my lord, I'm presuming worst against me that there is a fitment formula under the central rules which entitles them, though they have not shown it. Anyway, my lord, I am completely in agreement with, theoretically in agreement with what my learned friend says, that there is some formula, fitment formula available in the central government which allows them to distinguish. But the situation is, my lord, if the state government pay scale had continued, we wouldn't have been forced to enter into this situation at all.
So what are you seeking? You seeking the fitment formula in the central pay must be applicable to the state pay.
I am saying, my lord,
that's the effect.
The scale should be, the payment should, the pay should be parity. Whatever may be the reasoning assigned to that, my lord, I am not supplementing reasoning.
So that means,
yes,
whatever was the fitment formula given, made applicable to Nataraja's case, should be given in your case. We are not saying that on facts that cannot be given. We can say so. But even otherwise,
yes,
see what is the effect it will have. That means that henceforth, whatever the payment fixation of the central government must be given to the state, it will have across the state the same fitment formula which is applicable to the state.
No, divorce that logic, my lord. Without assigning that logic, if I may put it this way, my lord, if I had continued in the state, I would have reached equality.
Right.
And that without even saying, my lord, that fitment formula be adopted or some other reason be, without assigning any reason.
You look into this on this query.
Yes.
On this query, you can examine what were the state fitment formula.
I will examine.
Examine it. If you are saying that this is the fitment formula which were paramateria to the fitment formula of the central government, I should have also got the benefit, or I should have given the equivalent pay which he was drawing. Argue it.
Yes.
Leave that scope open.
If
I'm saying,
it
Lord,
is applicable, the 13th respondent will get more because it was 9,050 and theirs was 8,300. So he'll
No,
get more. Even if that exercise is done, it would be a futile.
Respondent.
That would be applicable to the
Because he is also governed by the state. You're right.
9030, 9050.
What she's saying is,
It would be more
one
vast.
formula is made applicable to you. It would also be applicable to the other gentleman. He will also have the benefit thereof.
It will be
No,
vast.
if the state government, the state scale is adopted, Now, my lord, we have migrated to the central scale for whatever reason. And there is a disparity. Rule provides. No, I'm only, my lord, one final submission I'm making. The Honorable Chief Justice, my lord, has exercised a discretionary option that is available to him under Rule 6B. Can an order exercising discretion be faulted with, is what I'm saying. This is one aspect your
Let's
lordship
see
may
that. Let's
consider.
see that.
Yes, lordship may see, my lord, that this judgment is premised on the fact, page 29, para 14 and 15, your lordship may permit me to read. In substance, petitioner and second respondents are all working in the same cadre as court officers. Am I reading with your lordships? Para 14. The fact that the second respondent is junior to the petitioner is not in dispute. Therefore, if the petitioners are senior to second respondent and petitioner and second respondent are performing the same duties as court officers, there cannot be any anomaly while adopting particular pay scale in favor of the petitioner in the year 2018. Rule 6B, my lord, is quoted. And then, in terms of 6B, employees of the court are entitled to seek curing of the anomaly from the hands of the Honorable Chief Justice. Therefore, representation was submitted and same came to be rejected with so-and-so. Memo takes shape so-and-so. Then, my lord, these judgments are quoted.
We will give you another possibly an issue which you must look into it.
Please.
Think over all then. See, what is now happening is you are not going beyond earlier to the court officer.
Yes.
You are starting from court officer. You say, remove the anomaly at that stage.
Yes, at court officer phase. That's all I'm saying.
Possible argument can be because you were promoted prior to him.
Yes,
That
Right.
was,
that is why, my lord, the honorable.
that extra pay is given to him. We calculate.
Yeah,
That's right.
Was given.
But that was the, and she also agrees, seniority is wise, you will be senior to that gentleman.
Yes.
Because you entered
That is
the
not in
court
dispute.
officer earlier.
Yes.
But think over this, can there be a judgment of any court if though a junior has been promoted earlier than the senior but still the senior is drawing a higher pay, the pay of the junior who got promoted earlier need to be
Stepped up.
The rules themselves say no, my lords. They have not challenged the rule.
Alala, that is not the situation. The junior now, the junior's salary is, my lord, more.
No, we are
There-
not on the basis of 6B. We are
Yeah,
only
yes.
on the basis of the concept of stepping up of pay. Will come in this case because mind it, her submission is this disparity has not come at the level of court officer. This disparity is historical.
610
That means
2004.
relates back to 2004. That's her case.
If it is historic, my lord, then we are, when we live in the present, when court officer.
We'll leave it at that. Look into it, consider it. We'll, if you want, then we'll give you, when do you want, tell us.
Just 2
spend
days,
all
my
of
lord, I will not retain your lordships. My submissions, my lord, are.
Like to argue, look into this and then make your submission, otherwise we'll close it.
Yes. Lordship may give me 2 days time.
Okay. We have heard the counsel for the appellant and the respondent at length. The request of Mr. Prabhu, re-notify, and just give us.
Those questions also, your lordships, and I will not let it be. Otherwise, there will be.
Say this, just say this.
Yes.
To enable Mr. Prabhu to look into the issue as to whether merely as to whether when you are the respondent number 1,
1 to
have
1 to 12.
1 to 12 having been promoted as CEO earlier to the respondent number 13, comma, the pay of the respondent number 1 to 12 need to be stepped up. Qua 13.
Yes.
Who was promoted as court officer on a subsequent date. That's right.
Only
Yes.
the problem is 2004, my lords. We are-
Alala,
irli, the question.
Why?
That's the
Your-
problem. I feel very.
Your stand
sad
remains.
this matter, my
We are
lords.
only saying possibly look
Ah.
into it. Your stand would be still, it's a historical.
Fifth, sixth and seventh.
No,
pay
the-
commission.
And mind it, man. This is not adversarial
Yes,
between
my lords,
either
It
1
only
to 12 and
illustrated.
13.
One of the saddest
Lines
beliefs
of-
I hold today because I am against few of the court
Just
officers.
that, see,
I
we
feel
are
very,
basically on a route.
No, she need not be so sympathetic, my lord. Let her be logical.
It's not
Sorry.
adversarial in that way, to be
Yes,
very
yes,
frank.
yes, yes, my lords, because we sat.
It doesn't cause prejudice to anyone.
Huh.
Unlike a seniority.
But it does cause prejudice in the sense, my lords, this is not the only thing that has happened. If such a thing happens, my lords, now it will be a random pay fixation for them.
No.
We have gone on a particular formula on.
That's right. That
if-
argument is there. That
Even
argument
for
is there.
all
for you.
cadres, my lords, this
Can-
would
Obviously, yes.
it
You're
would-
right.
it
You
create havoc.
will argue that.
And the central
Havoc.
government would have to step in.
Havoc
They would
in-
have to,
If logic is followed, my lord, if it creates havoc, then
the central government.
We will see. We will see. What is this? 21st.
Literally.
Okay. Next.
17, Banu Prakash.
For the appellants, your lordship, the filing a memo for withdrawal. The present appeal was as against the interim order in WP 482 of 2024. But as of 28th,
There is a shortfall of 100 rupees as court fee.
yes, we'll pay the memo.
She can deposit now. We will allow you, subject to you will deposit 100, the shortfall. This is a memo for withdrawal, which reads as under by the counsel for the appellant. We also find there is an office subjection of non-payment of court fee of ₹100. The counsel states, we are recording your submission, that the memo be allowed and the appellant be allowed to withdraw the appeal. Withdraw the appeal as she shall file the deficit court fee
Yes.
in the registry during the course of the day. Okay? Dismiss as withdrawn. Next.
18, number 18.
For the respondent, Madam my lord.
There were 13 complaints before the authority. 13 complaints were there, my lords. Individual complainants did not compute their investment. They say the total investment was 3 crore 94 lakhs. Against that, my lords, an appeal was preferred. 13 individual appeals or separate appeals were filed before the appellate authority. My lords, the appellate authority in 8 appeals holds that the order of RERA is without jurisdiction. In 8 appeals. It's a common order passed by the authority. It's an order without jurisdiction. In respect of 5 appeals, my lords, the appellate authority says you have not deposited the money in terms of section 43(5). Therefore, we are not entertaining this. Against it, my lords, the present appeals are filed. My lords, may kindly see.
What is a precondition to entertain the appeal?
43(5), my lords, undisputedly, my lords, says that I'll have to.
Simple.
My lords, but this honorable court, my lords, had granted me liberty to deposit a sum of rupees 2 crores for the matter to be taken up. I had deposited that.
Where is that order?
That order, my lords, I have filed it along with the memo at page 122. I have filed the memo, my lords. Along with the memo, it is at page 122.
Office.
Memo, my lord, was filed on 25th February 2025. Last page, my lords, page 122. Page 122, my lords. Last page. The order is dated 18/12/2021.
What was the subject matter of this restitution?
My lords, against the order passed by the authority, since I did not make good the amount, the complainants, my lords, went before the deputy commissioner and sought for attachment of the property, against which, my lords, the appellants herein filed a writ petition. The writ court, my lord, said, go and file an appeal subject to deposit of 2 crore rupees.
Very well. Then what happened?
Then, my lords, we deposited 2 crore rupees, then went to the authority, appellate authority. Appellate authority, my lords, this was the.
And this order said that deposit of 2 crores, all the appeals shall be entertained.
All.
Where is this order?
My lords, it's not with respect to all the appeals. The court said deposit 2 crores, by which time, my lords, all the appeals were filed.
Occasion for the Tehsildar to say or the petition was possibly filed within the
Authority order.
Rare order.
Please,
very set refund.
please,
Okay. Now then, you take this court
please, my
because of the proceedings initiated.
Yes,
by
my lord.
you. What has been said is you will deposit 2 crores
please.
and undertaking is
Before the real estate appellate tribunal, 18/12/2021 order is specific.
why not to encumber 5 identified facts.
Please,
These 5 identified facts were with regard to all the appellants,
Yes,
please, my
only which 5? And how many people were, how many?
five, there were 13 complainants, my lords. 13 complainants. 5 flats, my lords, was kept as security in case I failed in the appeal.
By the time did you file an appeal?
Yes, please, my
No.
lords, please, my lords. The appeal, my lords, was filed on 1/2/22, my lords.
What was the interim order?
stay of the proceedings.
Stay of the proceedings.
Yes, ma'am.
Stay of the
Of the Tahsildar. Tahsildar, yes, ma'am.
1/2/2022, my lords, immediately I filed the appeal. 1/2/22. I took an extension on 28/1/2022, my lords, to pay a further amount of 1 crore.
But you did not even file your appeal when this order was passed.
Subsequently, I filed.
Fine. So this order, this deposit would be for the deposit for the appeal.
It was.
My lords,
Like this when they initiate the execution maybe before the Tehsildar and the areas of land revenue.
It is for the stay of the proceedings of the Tahsildar.
That's what. Your appeal was not there.
my lords, but
There is no question of being followed.
But this money, my lords, was paid before the tribunal and it was considered as deposit.
Another appeal.
To the extent, the appeals or the claim were out of 30, how many? 8 were entertained?
Yes, ma'am.
Eight were entertained.
Entertained based on this. So they did not ignore this amount to dismiss the appeal. They said, we will look into this, we will consider this. But insofar the rest 5 which are their subject matter here, did not. And mind it, the law is clear, the section is clear, the law is clear.
One submission. The authority passes a common order on all the 13 complaints. Then against which, my lords, the 13 different appeals are referred by us before the appellate authority. Appellate authority says it's an order without jurisdiction, keeping in mind, my lords, the law declared by the Honorable Supreme. The order, my lords, is.
Then why did you adjusted this amount against 8 crores? Should not have said. See, that is the very proceeding before the authority were not doing it. Ready? Suppose there were 30, there were 20 aliens to be filed. You would have adjusted all these against even 20 also.
Please, my lords.
See, there is some issue where the penalty for compensation, how much, 30% also. When it comes to the complete amount which has been paid, that need to be refunded. Yes.
We have taken up that contention, my lords. Taken up that content. Saying that in view of the judgment of the Honorable Supreme Court, it could not have been.
But it was still before the applicant.
I understand.
Exactly.
Still before the applicant. He's under 43(5).
They're bound to.
It is not a case of compensation or damages which have been awarded.
Please.
Please, what amount they have paid?
For specific case, my lords, was they were investors and never allottees. My lords, even the complaint, my lords.
Still they were out of pocket. Was not to be.
Yes.
That's the.
You make a submission, my lords. That's my kindly have it on Monday. I take instructions regarding withdrawal of this appeal. So.
Also, take instructions.
It's in Bombay.
For yesterday you have taken instructions. Also, please.
Great.
Yes.
Kindly before this is an appeal against. Yes, my lords. I recently became aware of the Honorable Division Bench of the Bombay High Court judgment, my lords, that on rejection of an IA under Order 7, Rule 10, appeal is not maintainable. Allowed.
Allowed or stated.
Yes. Yes, my lords.
This is not such a case.
Yes, my lords. Therefore, my lords, I may be permitted, if I may be. May I request, my lords, that commercial appeal, I may be permitted to withdraw it and convert it into a writ petition, my lord.
No, that we will not. We will see. The format is different. We can record your submission. That the petition appeal is not maintainable. The petition should withdraw it to seek such remedy as permissible. Dismiss and withdraw. You can't be remediless now when it is
Yes,
not maintainable.
yes,
You can't insist upon no.
I agree, my lord. If I may be permitted to convert the same appeal into writ petition, lord, that.
But we don't know the format is different. Is it not different?
Yes,
and it's this you this one.
No, the.
You still prepare a petition and file it.
Yes, my lord.
We say nothing on the maintainability of the petition or whatever we want to file.
The only reason is, my lords, that this honorable court has stayed the proceedings before the learned trial court. So therefore, my lords, if I withdraw this appeal, my lords, without seeking permission to convert it, then the interim order goes, my lords.
I'll leave it to your lordship, my lord. It can be extended for a period of, say, 20 days.
Grateful.
And let him pre-serve a copy so that I can appear on the first date.
See, 21/4/2023.
21/4/2023 extended this files the petition.
My lord.
Seek the remedy before the appropriate court.
Very good.
For the appropriate court. Within 20 days, sufficiently given to the legal counsel for the respondent. If that is so, the appeal is dismissed as withdrawn. And taking is sufficient made by counsel for the respondent as the benefit of the interim order shall endure to the petitioner for the next 20 days from today. Okay.
May I be requested to serve a pre-copy of?
Yes.
Injunction suit, trademark infringement, has been dismissed by allowing the Order 7 Rule 11, my lords, on section 430, saying that it's barred by section 430 of the Companies Act. Therefore, the suit is not maintainable. Without observing the fact that the prayers in both the petitions are completely different, I prepared a chart.
As I appear for R1, my friend has to first cross the Rubicon of delay, my lord. It's barred by limitation.
No, I'm the appellant. I'm the appellant. Because there are two grounds. Number one, my commercial suit, if my lords would want to hear on delay, I can satisfy on delay. My lord. What has been passed in this is an Order 7 Rule 11 application that has been allowed. My suit has been dismissed. My lord. My lord. I have. Just take off. I will just do. First read this 13(1)(a). Any person aggrieved by the judgment may read. Any person aggrieved by the judgment or order of a commercial court at the level of district judge exercising original civil jurisdiction, or as the case may be, commercial division of a high court may appeal to the commercial appellate division of the high court within a period of 60 days from the date of pronouncement of the judgment or order, provided that an appeal shall lie from such orders passed by commercial division or a commercial court that are specifically enumerated under Order 43 of the Code of Civil Procedure 1908. 711 has been accepted. 711 has been accepted, undoubtedly. Appeals from orders. An appeal shall lie from the following orders under provisions of section 104, namely. What is there under Order 710? My lord. My lord. 11 is not. My lord. Not there under this appeal under 32. My lord, can I just answer in two lines, my lord. Number one, my lord. One on the fact of, I would want to justify, my lord, if not today, then on some other day, but there is a reason why I'm asking for this time, my lord. Thrice the matter has come up, there has never been an objection on maintainability of the commercial appeal. That is number one, my lord. Number two, my lords, the injunction, the temporary injunction order, Order 39, Rule 1 and 2, traveled up to the Honorable Supreme Court, my lord. And on 17th January 25, between the same parties, my lord, there was a liberty given by the Honorable Supreme Court to agitate all the issues in this appeal. There also, they have not raised any objection with respect to the maintainability of the appeal. Of course, on law, I need to satisfy. I will not run.
May I say something on this?
It can come from the court. There is no doubt about it. But therefore, if I may, my lord.
May I say something on this, my lord, process permit? But may I?
Will this order shall have the effect of completely dismissing the suit?
This would have the effect of dismissing the suit. It dismisses the suit, my lord. And as an officer of the court, according to me, as an officer of the court, the appeal, according to me, would be maintainable. Would be maintainable as a Section 96 appeal.
It's had the effect of dismissing.
That's correct. That's correct. So my friend is right in contending that we haven't objected to the maintainability. However, having said that, this appeal is barred by time. There is a delay of 366 days. My friend would allow me. There is a delay
If
of
I can complete,
360.
let me start. I'll
My-
justify on delay.
One second. Allow me to make my
Very good.
submission. But there is a delay of 366 days, which according to us has not been explained at all. And in fact, there's so-called explanation in the condonation of delay application, but if I dare say, is factually wrong and possibly not bordering on dishonest. I can satisfy losses for not. We are contesting that application.
You're relying on the government of Maharashtra.
No, I'm not relying upon government of Maharashtra. There was an existing dispute between the parties, my lords. If I can just explain in 2 minutes. It's the petitioner, my lord, is a company owned by 2 groups, the Highgrieve Group and the Narayan Group. 50% shareholders of shareholding of both the group. However, in the board, my lords, Highgrieve have 6 directors and Narayans have 2 directors. From 2014 onwards, my lords, the parties are fighting in various forums for some alleged family settlement agreement. All courts have held against the Narayan Group. The respondent 1 company, my lord, is a 100% owned entity of the Narayan Group, who continues to be a director in the petitioner company even as on date. He's a 50% shareholder and 2 of their directors are in my company. 100% owned entity of the respondent number 1 is a 100% owned entity of the Narayan Group. When in NCL, so one of the Narayan Group for enforcing that alleged document went to NCLT in 2014, claiming rights under that alleged family settlement. NCLT dismissed. They finally went to NCLAT, still pending, no stay granted. In that NCLAT, my lord, the Highgrieve Group had given, I will take my lords through the paper, but just in brief, if I can explain, then I'll show all the documents.
My friend is not answering the question of delay. My friend has to first answer the question of delay.
Sir, if you don't mind, please.
With respect. No. But I have an objection on maintainability.
I am coming to that.
1 minute, Mr. Mehta, just 1 minute.
Please.
What is being contended is on the delay application.
Yes,
How much is the delay?
366 days. There is a reason to that. I'm just coming to that. In that proceeding before NCLAT, my lord, which was initiated by the Narayan Group, the Highgrieve Group had given a voluntary undertaking, saying that we will not hold board meeting till the next hearing date. That IA was pending from 2019 even till today. From 19 to 25, the IA was kept pending. That is point number 1. I'm coming to the exact reason for delay. Point number 2, my lord, my order 39 rule 1 and 2 in this very matter was rejected on the ground of there being no board resolution, because it was filed by the chief financial officer, the lower court, trial court, the commercial court rejected it. I came in an appeal before this honorable court. This honorable court confirmed the order of the trial court, rejected or upheld the order of the trial court, saying that because there is no board resolution, hence it is not maintainable. I went on to the Honorable Supreme Court. Supreme Court 2 months back, I went to Supreme Court in 2023. 2 months back can be contended here. Now this appeal, my lords, what the suit in meanwhile has been dismissed, my lord. The plaint has been returned. And in the application that I filed for condonation of delay, my lord would now see the document. I say that 1, I was pursuing my remedy before the Honorable Supreme Court. And I was also awaiting the outcome of the NCLAT application, which is still pending. I specifically state that it is between the same parties. There is no dispute in that. So therefore, that is the paragraph that I take in my application for condonation of delay. In fact, my lord, I had the occasion to assist the Honorable Supreme Court in this very matter, which went till the Honorable Supreme Court. There also this ground of delay was taken by the other side, to be candid, my lords. And the Honorable Supreme Court did not consider. Therefore, that recent order, which has been passed on 17th January 25, I will just show that, my lord, says that all questions are left open for this Honorable Court to take a decision. That's on facts. On law, my lord, the Supreme Court as well as various high courts have held that in a suit for infringement, it is a recurring cause of action. This COMAP, my lord, is nothing but a continuation of my commercial suit. So therefore, if on law I need to satisfy every day, because these marks, despite all courts holding against them, these marks are being unfairly used by, if I choose my words carefully, my lord, by a set of directors. Despite the fact that these very marks have been stayed by the IPAB, again confirmed up till the Honorable Supreme Court. So therefore, my lord, where am I? I am ultimately on this point that I have been pursuing my remedies immediately once the suit was returned or rejected under Order 7 Rule 11. I went to the IPAB, if my lord would now have the dates, The dates are important because everything is a scheme, is in one line.
Now, these are the NCLAT proceedings at pages,
Lord are having a look at the paper.
pages 212. 212 is, yeah, no, that's this thing, that's NCLT. And NCLAT.
It's 212 is the final order passed. 2110 it starts, 210 is the
Where
final.
is this NCLAT order?
The NCLAT order is not here, my lord. It is pending. It is sub judice. It is not been
No,
decided.
what is that 281?
281, my lord. Just a
Hmm.
second. 281 is, my lord, the undertaking.
That's also NCLAT order.
That is NCLAT. That is the undertaking that was given, my lord.
Are there any other orders of NCLAT?
There are other orders that they're interim orders. There's no final order of NCLAT. There is no stay.
You have those orders?
I will get a printout. It's not on record,
Huh.
but they're all interim orders saying the matter heard next date, matter heard next date.
You
Interim
just
orders.
file it on record. Okay.
Very well. We'll file that on record, my lord. There are two things very, very important, my lords, if I can point out. 17th February 2022 is the impugned order. My lord. Prior to that, if 3 dates, my lord could note, my temporary injunction was rejected on 20th February 21. 20th February 21. This Honorable High Court confirmed in a commercial appeal the order of trial court on 27th May 21. Thereafter, an SLP was filed, my lords, which was pending, and that came to be disposed of, as dismissed as infructuous on 17th January 25. That is for the temporary injunction. For the main suit, my lord, 17th February 2022 is the impugned order which my lords are dealing with. And 19th April 23 is when I came before this honorable. Now, kindly, in this context, kindly have a look at the Honorable Supreme Court's order, my lords. With all due respect, my lords, once that is the Honorable Supreme, we have filed a memo, my lord, on 4th February 25. February 25, my lord, we have filed a memo.
I don't want to interrupt my friend, but this is not the reason for seeking condonation. Nor can it be, madam. Nor can it be.
You can just take the I for the recent one, IA1, which is a part of that order also. Can you just tell me the page number of the IA? Yes, we have separate copies also, my lord. It is on record, but just not to trouble my lords to go through the lengthy paper book. Can I just tender a copy of the order which is passed between the same parties out of the temporary injunction? Kindly have the cause title. My lord would see the impugned orders of 27/5/21 on the top, which is the temporary injunction, and that POMAP earlier was 61 between the same parties from the same very suit. And then my lord would come to the second page. And this is not at the first day, my lord. 7-8 times the matter was listed before Honorable Apex Court. Never, when this liberty was being granted, of course, an objection with respect to delay was taken, but Honorable Court said nothing doing, we will remand everything back. And therefore, the relevant, my lord, would have seen.
On a maintainability, I don't think there is an issue now.
On the delay as well, my lord.
Only
On
on-
maintainability
No,
delay,
I'm sorry,
both
but
these
there is an
aspects-
issue on
If you
delay. My
don't
friend
mind,
is
sir,
completely
please let
wrong.
me-
My friend is
Please
completely
let
wrong
me
on that.
complete. Please let, Lord,
No, he is only answering the delay, Mr. Mehta.
Lord, I was there. I had
But
the
I know
occasion
that,
to
but there is
assist.
that issue. But I'm
Mr.
sure my
Mehta
friend
was-
is assisting.
Mr. Mehta was not in court on that day. I was as a responsible
Yes,
officer
yes,
of the
go
court,
ahead.
my lord.
What
if
is
I
the
may-
submission on delay?
Well, the submission of delay is twofold, my lord, as I said. Number one, my lord, that in my application, my lord would kindly have my application for condonation of delay. The relevant at para 4, my lord. If I may read, my lord would have it. I state that since the petitioner was awaiting the outcome of IA number so and so, Lord would just have the application. Para 4, of my application for condonation of delay, I state that since the petitioner was awaiting the outcome of IA 1075 of 2021 in Company Appeal 80 so-and-so, which is the IA to withdraw the voluntary undertaking given by the petitioner. However, during the pendency of the same, several actions have been undertaken by respondents to the detriment of the petitioner. Para 5, that the subsistence of the impugned order will have disastrous consequences for the appellant's business, the perversity of the findings, and therefore what I ultimately aim at is, my lords, that this IA which I had filed within 7 days of my temporary injunction being rejected. Temporary injunction was rejected on February 21. Within a few days, I filed the IA before the NCLAT, my lord. And that IA is still today pending. But because of these proceedings being hampered, I filed a memo in December of 24 before the NCLAT saying that I want to withdraw my undertaking. That memo has been challenged by the other side before the NCLAT. No stay order passed, no effective order passed. I have now passed a board resolution also, my lords, authorizing the very same appeal. On 15th January 25, I have placed that on record. I have passed a board resolution because it was on maintainability and 430. The impugned order is on 2 grounds: maintainability, saying that there is no proper board resolution, and section 430 bar. On both these aspects, one on maintainability in terms of there being no board resolution, I have passed a resolution on 15th January 25 as recent as 2 months back. And on 430 is what I'm trying to satisfy. But on the delay, my lord, on one is that I was awaiting the orders, one of the Honorable Supreme Court, and as well as the Company Appeal 65. That is on facts. That is my explanation here, my lord. The second explanation which I have is on law. There's one judgment, there are 2 judgments, my lord, which I want to rely, that in an IPR in trademark infringement suit, since there is a recurring cause of action, the question of delay will not come against me. The reason is this, my lord, that it is not a case where my suit has been decreed or I am getting some benefit out of the order. My grievance qua the infringement continues today because I did not get a temporary injunction because of the objection taken by them. Even before the Honorable Apex Court, I could not place my case because this appeal was pending. Now, in this entire scheme of events, my lord, where the trademark registrations for them have been stayed by a detailed order of IPAB, this Honorable Court dismissed a writ petition challenging that. They went to the Honorable Supreme Court, withdrew it as dismissed, and then the final rectification proceedings are pending before the Honorable Madras High Court. In this scheme of events, my lord, and where all courts, which I can show, whether the company who's trying to safeguard its rights from its own directors, and I have a legacy of about 160 odd years, my lord, which the respondents and the promoters of my company, way back in 1980, had agreed that the entire legacy from 1869, because I'm one of the best jewelry businesses known in the south of India, southern India. So from 1869 till 1980, whatever was the goodwill, that had to be transferred to the petitioner alone. There is a dissolution deed which I placed on record. In this scheme of event, my lord.
But tell us one thing,
my lord.
See what is the delay is challenging in a particular order.
My lord.
Absolutely.
So what prevented you,
my lord,
to challenge it within the prescribed limitation?
My lord.
Merely proceedings are pending. Would those proceedings have a bearing insofar as the impugned order is concerned?
My lord.
Does it have? It may not have.
My lord.
Because ultimately what has been done is the suit has been dismissed.
My lord.
That's the effect.
That's
so
the
you
effect.
should have taken steps immediately thereafter.
The answer.
And we are in a commercial appeal.
My lord.
The limitation is prescribed. The law is well settled. Very narrow window. Narrow window, it should not be a large delay and no negligence. All those parameters.
My lord.
How would you come within those parameters?
My lord. I can make an endeavor today to justify on that, my lord. There are 3 aspects date by date as to what was the reason.
So will that be, see, one thing, you may have some justification date-wise.
My lord.
Saying that this is what,
my lord.
But that would be large delay. Something very small delay possibly, and it should not be a negligent that you did not pursue the appeal for XYZ reasons, which shows the negligence on your part.
My lord.
You may argue, but there was no negligence. But surely the delay being so.
Let's make this very clear, my lord. As I said, that the temporary injunction, I'm trying to justify on facts alone, my lord, not on law as well. the temporary injunction was rejected on the ground that there was no board resolution. This honorable court passed a detailed judgment in May 21, saying that whatever the temporary injunction the commercial court has held is correct. A division bench in a commercial appeal here passed it. I went to the Honorable Supreme Court. Meanwhile, the suit is dismissed. So and on the same ground, the ground that was taken in the temporary injunction is coinciding with the ground taken in the
But that appeal which went to Supreme Court is on an injunction.
is on a rejection to grant injunction on the ground that there was no board resolution.
But let's assume for a moment.
Hold on.
Let's assume for a moment that order is reversed.
This order
Will that mean the order dismissing the suit would also go?
No, that will not mean that the order
That
dismissing.
will trigger the appeal, no?
Yes, the answer to that is this: the findings given by this honorable court in the commercial appeal filed by me at a previous date will come in the way, my lord, respectfully, because it is the entire same issue. The issue in this case is also that whether a chief financial officer who is now ratified could initiate the suit. That is also one of the ground taken in the impugned order here. So if there is a finding issue looked into by this honorable court, which is the final order in a commercial appeal by me, and I am again agitating the same issue before this honorable court, most likely, my lords, with respect, I would say the issue would cover this. Hence, to suffer another dismissal on the same very issue, my lord.
The injunction was rejected on the ground of competency of the.
Yes,
no
exactly.
competency of-
Only on this ground. Only on this ground. And the commercial appeal that was filed in this court by me was also rejected on this ground, saying that there is no competent.
Very well. You did not rectify that deficiency?
We have rectified, my lords. We have.
No, at that time when the injunction was rejected.
We did not, because we pressed before the NCLAT. There are at least 25 dates before the NCLAT where I went again and again, please hear my IA, please hear my IA, please hear my IA. The NCLAT never heard it. Even today, it's not heard. So therefore, because of other things coming in, I chose to file a memo because it was a withdrawal, voluntary undertaking. I said, I will withdraw my undertaking, which has now been challenged by them before the NCLAT. There is no stay order. They have pressed thrice for granting stay. So therefore, my lords, if the same issue has been decided between, in my respectful submission, between the same parties, the concept of issue estoppel will come in, my lord. And hence, to suffer a second negative order on the same very aspect is something which I was awaiting, and therefore
How would you overcome 430? What was the ground on 430?
Yes, the answer. I'm so grateful if that is the question.
Because that's also a ground.
That's also a ground. That is, in fact, an easier ground to defend, I would say, my lord. The reason is this. What has been stated in the impugned order is that the prayers between the company petition filed by the majority shareholders, which is pending in NCLT, majority board of directors, and the prayer in this suit, which is initiated by the company, is identical. Factually incorrect. I have prepared a chart. The prayers are absolutely different. That is number one. Number two, my lord, that NCLT proceeding is initiated not by the company. It is by a shareholder in their capacity as a shareholder. This suit is initiated by the company. That's number two. Number three is, my lords, there are consistent view taken by various high courts, my lord, that an IPR infringement, trademark infringement suit can never be barred under 430. A trademark infringement suit, which is to be tried by commercial courts in various states, can never be barred under 430. It can never be hit by 430, I would say. So therefore, NCLT cannot have jurisdiction to look into trademark infringement. It is only the civil.
What prevented you still to file an appeal within time? Because there is a 430, which is a different ground, which was not a ground in injunction order.
My lord.
You should have filed it.
Yes, the answer
How
to
would
that
you
is
answer
this.
that?
The answer to that is this. I would reach the hurdle, or I will meet the argument of 430 only if I would have cleared the hurdle of lack of authorization. That is what the impugned order holds. The impugned order says, first decides the fact that when there is no authorization, forget everything. But they also hold that it is barred by 430. Now, it is easy for the other side to argue, and as I must be fair to the court, my lord, that first test on authorization. If there is no authorization and this honorable High Court has given an order against me, Supreme Court is considering it not stayed for whatever reason, then, my lord, to reach section 430 would have been a task for me. Because if I can't defend on authorization, why is the question of going into 430? And that is what the impugned order also does. It starts with the fact
We'll
that...
come back after.
Very well.
Deep reply. Deep reply.
Submission, my lord. Serial number 23, there is an office objection, a single office objection is there. I have to raise the same, my lord. Your Honor, kindly grant me 1 week's time.
Just say at the request of counsel for the appellant re-notify on. 23, you said, no?
Very well.
Just give
Serial
June,
number
ma'am.
21, my lord. Then, recall
Which number,
application-
ma'am?
Serial number 21, my lord. I had filed recall application for.
Yes, ma'am. Yeah, yes, ma'am. You have a recalling application, no?
My lord,
No, not you, ma'am.
23, 23.
I have got the restoration application filed.
Yeah, it's been dismissed. So what do you want to remove the objections?
There is the office has raised one of.
Yeah, do that.
My lord,
The
serial
request
number
of counsel.
21, my lord. We have filed recall application to restore the
Which
case.
one, ma'am?
Serial number 21, my lord.
Hmm?
Kindly allow the application for compliance of office objection, my lord.
We'll remove it, we'll adjourn it to,
Serial number one.
My lord?
Serial number 132, ma'am.
yes, ma'am.
Here, the connected appeal.
Just say that at the request of counsel for the appellant
Appellant, my lord.
to remove the, just 1 minute, we are on 23, 21. To remove the office objections, re-notify on.
2 weeks time.
Just have it on 23/4.
Much obliged.
Serial number 32, ma'am. Where? 32. 30.
32, you said?
32. The respondent has filed one more appeal, ma'am. And both may be posted together. On the
No,
same-
you appear for whom? Or you appear for the appellant. When did you file it?
I filed the 7-3, ma'am.
So you have to get it listed, no?
Yes, sir. It is
So we will,
for one
we will at joint request adjourn it. You get your appeal listed on that day. Just say at the joint request of,
serial part.
My lord, passed over matter, serial number 15.
we can hear only one person at a time. Just 1 minute, Mr. Shiv Kumar, just 1 minute. Now, we take it, you have filed an appeal. You want to get it listed,
Yes, ma'am.
so we'll adjourn it this, you will get it listed on that day.
Yes, ma'am.
Yes, now what do you want? That 1 minute, we'll see it. Just say this, at the joint request of the council for the parties, re-notify. Just give a date in June.
9-6.
Then interim order, if any, to continue till the next date of hearing.
My lord, serial 43.
43, what
I
is
want to
this?
withdraw the WP, my lordship, as a infrastructure. WP, serial 43.
Yes,
The respondent is out of service, but compulsory retired out.
so what do you want?
I want to withdraw that should be disposed of as a infrastructure,
Mr. Baswaraja, learner counsel for the petitioner states that the present petition has become infructuous
Yes, my lordship.
and he wishes to withdraw the same.
Yes.
See, what is this, ma'am?
Serial number. Compulsory retired out.
And as such wishes to withdraw the same. The petition is dismissed as withdrawn.
He has been compulsory retired out.
No, just say this, Mr. Baswaraja states as the petitioner has been compulsory retired.
No, respondent has been compulsory retired. Respondent, I am petitioner.
Okay. Now, who is withdrawing it?
I am petitioner. I filed the WP.
You are for the ESIC?
Yes, my lordship.
You are for the ESIC?
Yes, my lordship.
States that as the respondent has been relieved of his duties on his retirement.
Compulsory retirement under a part 56J.
On
premature
his
retirement.
compulsory retirement, he wishes to, the present petition has become infructuous and wishes to withdraw the same, dismiss as withdrawn.
Yes, my lord.
Serial number. My lord, passed over matter, serial number 15.
Just one. Yes, what do you want?
My lord, this matter, serial number 15, there is some personal inconvenience in the afternoon session. I request of Friday.
This was coming from yesterday, no?
Please,
In
my-
this matter, I appear for the National Medical Commission, respond number
Oh, you
2.
appear for National Medical Commission.
My name is not shown.
See, there is, in fact, they have really, based on your stand, the learner single judge has disposed of the petition.
Yes, ma'am.
So we'll just look into it, come back after lunch.
My lord, serial number 27, my lord.
Who is the other side?
Please, my lords, today they have served a better affidavit, my lords. Kindly have it any day in the next week, my lords.
Who is that? Who is for the, you are for the?
I am for the respondent.
Just say at the request of counsel for the respondent to look into the affidavit filed by the appellant to re-notify on.
My lord.
Not kind leave, my lords. Serial number 18, my lords. Withdrawing those appeals. My lords.
You're withdrawing it?
Withdrawing those.
Just say that the counsel for the appellant has filed a memo. What is it memo?
It's a memo, my lords, for withdrawal.
Memo which reads as under.
With the liberty, my lords, to take appropriate recourse, my lords, in accordance with life available, my lords. Because I can go back and, my lords, make a deposit and still ask for revival of that order, my lords.
For the respondent is matter. No, you want to pay the differential amount and then proceed with the appeal.
I want to reserve that liberty, my lords, because if I go back, my lords, if it's a simpliciter withdrawal, if I go back, my lords, they'll say appeal is withdrawn.
So
They'll not,
that order would still remain. Does that order doesn't give a liberty to you?
no, my lords.
You show us.
No liberty is reserved.
Which part of the order governs you?
My lord says appeal number 2, my lord, appeal 2 of 22. At page 35, my lords, internal page 6 of the order. See, my
No,
lord,
this is 15th June 22, no?
my lord, sir. Please, my
50
lords.
Which order you are reading?
My lords, order which is produced along with appeal, my lords. What my lords are looking into, I think, is the order which is produced along with the documents. Along with appeal, my lords, the impugned order is produced at page 30. Operative portion is at page 35, my lord.
So what will you do against this order then, once you are withdrawing the appeal?
But still, I will have that, if the liberty is reserved, my lords, still I can go back, my lords, ask for revival of this order by depositing the amount, my lords.
So then we may have to modify the order.
No, my lords, I'm only asking for that liberty to be reserved. If at all, my lords, they can arrange for funds, my lords, I can still go back there, my lords, and seek for revival of that order.
Under what provision?
Lords, I'll not file another appeal, my lords.
How?
Because
This
it
appeal
is,
will
my
get
lords,
final.
My lords, it is not dismissed on merits, my lords, it is only because I have not deposited the amount.
Then if that's your understanding, you go back. We say nothing.
Please.
Okay, we say nothing. That's your understanding, you go back. You say that which reads as under, the learner counsel for the appellant reiterates the prayer for withdrawing the appeal. The appeals are dismissed as withdrawn.
Great.
Okay, thank you.
Serial number 27, your lordship. Small inconvenience, your lordship. Senior is held up in court hall 4 in part heard matter, your lordship. 7, your lordship. I am for petitioner in that matter.
$19,600.
Yeah. So my lord's convenience, my lord wanted to see the orders passed by NCLAT. I prepared a small chart and maybe I will be able to satisfy my lords on the question of limitation alone. If I can just tender these. I'm sorry. I'm sorry. I'm so sorry.
For announcement. Yes, Gupta, Shri Ravi Shankar.
Responding, my lord.
Some judgments.
That's such a good case. The appeal there should not be any point there to myself. I appreciate I was very confident. No problem.
Lord would kindly have to answer the question on the limitation, my lord. Would my lord kindly have the Limitation Act, section 14(2) for a minute, on the fact that, my lord, that if I am being bona fidely pursuing my remedy, at the end of the day, my lord, there is a bar for me to hold the board meeting by an NCLAT order. I have given an undertaking, which I'll just show, my lord. And I've been pursuing my remedy since the day one till today there, my lord, before the NCLAT, not against the impugned order, my lord, but before the Honorable Supreme Court. So therefore, these two charts may be important. Can I just? Indeed, my lord. Against the earlier impugned order, which has the same finding. If my lord would kindly see for a minute 14(2) and how the Honorable Supreme Court in a recent judgment is interpreted to say that the jurisprudence for limitation, in my humble, my lord. Indeed, my lord, because I can't take the same ground. No, 430 may not become final on this. 430 may not become final, my lord.
Still had to be on 430.
My lord.
Surely, insofar as 430 is concerned, we should have filed an appeal. Maybe incorporating the same law which we have taken in the arrest.
Indeed, my lord. And both have been done at the same very time. The Honorable Supreme Court SLP was also filed at the same time, and the COMAP was also filed at the same time. The point that I'm trying to urge is, my lord, if my lord would just have for a minute the chart that I prepared during this lunch session.
My lords, I'm sorry to be interrupting. I'm told that they're unable to hear your lordship, saw my learned friend on the VC.
We just switched off. We have switched off. Yes.
My mic is. In my humble submission, my lords, the test or the question that I would put to myself is, my lord, that was I diligent or was I sleeping over my rights? That is the question that I would put to myself. And that is what I would urge my lords to consider while deciding the limitation alone, my lord.
Generally, tell us one thing.
My lord.
Generally, what happens? The issue is pending in one of the cases, but you will still file an appeal.
My lord.
File it, get it listed, saying that that issue is pending before the Supreme Court. Please await the outcome.
Lord.
That's the proper way to do
That is the proper way to do it.
And mind it, that's only on one aspect. The second aspect of 430.
Yes, for that, my humble submission is, my lord, for me to reach the 430 aspect, as I was trying to put in, my lord, for my lord's kind consideration, I need to first cross the hurdle, my lord.
Obviously.
Proper authorization.
Some of that will have a bearing in that, will have a bearing in 430. But still, I'll file an appeal.
Indeed, my lord. And that is what I state here. But of course, with a delay of 366 days, there is no quarrel about that. There is a delay of 366 days. In fact, before the Honorable Supreme Court, there was a delay of 400 days. And there was an objection filed by the other side to dismiss it on delay. It is not dismissed on delay.
But that Supreme Court said the appeal has been filed, you will work it out.
Indeed. And it is not on the first hearing. So therefore, my lord would kindly have the chart for a minute.
Yeah, we'll look into it. Yes.
Lord would kindly have, there is one chart which says table containing the effective orders of NCLAT and Company Appeal 65 of 19. The first chart. There are two charts. One is titled table containing the effective orders of NCLAT in Company Appeal 8065 of 19. My lord may kindly have serial number 1. This is the order by which this is dated 23rd July 19. And the order, if I may read, my lord, Mr. So-and-so representing so-and-so and so-and-so have appeared and stated at the bar that the proposed 425th board meeting of 24 July shall be deferred till the next date of hearing of the appeal. We treat the statement made by the learned counsel for the respondents at the bar as undertaking given to this appellate tribunal, and having regard for the same, we dispose of the IA with directions that the proposed meeting shall defer till 1st August 2019. Now, this order has been extended till almost January.
Just 1 minute. We want one clarification on fact. You filed this appeal after the Supreme Court or before?
The present appeal, my lords? The present appeal is filed 1 month after the Supreme Court.
1 month after.
After the Supreme Court SL.
Then where was the occasion for the Supreme Court to say that an appeal has been filed?
The Supreme Court, by the latest January order, my lord, while disposing of the SLP, says that now because the commercial appeal is pending, what had happened is, my lord, before the Honorable Supreme
That's
Court.
a different order of the Supreme Court.
No, so if I can just, can you give that chart? This is for clarity that what went ahead. Can you please?
This is what you have placed before us.
Yeah, this is the order of the Honorable Supreme. If my lord will just have this chart for a minute. This is showing that what temporary injunction, which side we are just tendered. Can you give a soft copy to them, please? We have one more copy. This makes it clear the ladder. Can you give a soft copy?
Yeah, tell us.
Lord would see kindly. First is the suit which is mentioned on top. Left side is the temporary injunction. Right side is the present proceeding. Left side, my lord would see is the order dated 20th February 21, which is rejecting my temporary injunction on the lack of board resolution. Then my lord would see the first commercial appeal that is filed 61 of 21, which this honorable court confirms, saying that whatever the trial court has held is correct. And also in the temporary injunction, there is a obiter which says that the suit is not maintainable because proceedings are pending before NCLAT. It is not dismissed on that ground, but there is an obiter in the temporary injunction order. I will show these paragraphs if required, my lord. Then is the SLP against this honorable court's order, which is the third in the left side, my lord. Filed on so-and-so, disposed on so-and-so. It should be January, I'm sorry, my lord. With liberty to the parties to raise all pleas and contentions before the this honorable court in the present. On the right side, my lord would now see is the meanwhile. So after suffering from this honorable court, I went to the Honorable Supreme Court. Meanwhile, my suit is rejected on the ground of Order 7, Rule 11. And then.
So we are on this.
My lord.
You filed this appeal when Supreme Court was seized of the SLP.
Yes, I filed the appeal when the Supreme Court was seized of the SLP.
So you did not wait for the conclusion of the Supreme Court.
I waited. That's why I'm arguing it now, my lord. This was filed in 23. Yes, my lord. It was filed in.
The impression we are getting is,
my lord.
I did not file this appeal because the SLP was pending.
My lord.
It's not that.
It's not that, my lord.
SLP filed, you also filed this appeal without awaiting the final conclusion of the Supreme Court.
It was kept in defects. It is still in defect. And after the Honorable Supreme Court's order, I mentioned before my lords were kind enough to list it in February. Within 4 days of the Honorable Supreme Court's order, I mentioned it. For 2 years, it was not listed. Then
you could have filed it even before, even approaching without any delay also you could have done
we
it.
could have done it, my lords, but the apprehension was this, my lord, and I must be fair to the court. The apprehension was simply this. Lying upon 14.2 of the Limitation Act, my lord, where I stated in my application that that chart that I had shared for NCLAT, my lord, was seeing that first order is of 23rd July 19. And then my lord would kindly come to serial number 9. 8621, my lord, have that, is an IA that was filed. So this is June 21 after suffering the temporary injunction order. After suffering the temporary injunction order, I file an IA. The present impugned order is of February 2022, 6 months later. From June 21, which is serial number 9, till almost 57, the present date, this IA has been listed every time, every order records it, but no orders have been passed. But what is important is 53. Serial number 53 at the third page of this NCLAT chart that I have given, my lord. Serial number 53.
What was the prayer in the IA?
The prayer is that please let me withdraw my undertaking because I am suffering the same very parties challenging my locus, that I cannot conduct a board meeting, I can't pass a resolution. So therefore, please let me withdraw the undertaking so that I can now have a board meeting.
To overcome that, the ground for rejection.
They overcome the ground for rejection. And that IA, the orders were never passed. Therefore, at 53, serial number 53, I filed a memo that because of the grave injustice being caused to the company, which is a joint shareholding of both these parties, kindly let me withdraw the undertaking. At 53, serial number 53, I filed that.
That's the prayer in 1075 also.
That is a prayer in 1075 also. But it was a voluntary undertaking, so I filed a memo. Now they have challenged the memo, sought for a stay, the stay is not granted. Meanwhile, what has happened, my lord, because the undertaking was only qua board meetings. I have passed a resolution through circulation on 15 January, which is not challenged by them till date. The resolution through circulation, I have not conducted a board meeting, saying that because the company's rights are being prejudiced for whatever fight is going on between the shareholders, I am ratifying the I am ratifying the CFO, the person who has now instituted the suit. And that was produced before the Honorable Supreme Court also, because the order of the Honorable Supreme Court is 17 January. Saying that because of this resolution that I passed, at least now let me protect my IPR, or let me now protect my trademark rights. On that basis, my lord, now kindly have 14.2. And the second chart is of the Honorable Supreme Court, my lords, that the matter is being heard there since past 2023. It has been listed 8 times. Parties were referred to mediation. Justice, one of the Honorable retired judges of the Honorable Supreme Court looked into it. And thereafter, 8 times the matter was heard. So the second charge that I have tendered.
So pending SLP of the Supreme Court is not a ground for you not to file the appeal.
Is not a ground, my lord. But see 14.2 for a minute, read with this recent judgment, which says that 14.2 exclusion is to be given to meet the ends of justice. So therefore, if my lords would now have 14.2 for a minute, that my attempt is to persuade my lord, ultimately, my lord, kindly have 14.2, my lord. In fact, 14 may be seen exclusion of time of proceeding bona fide in court without jurisdiction. 1, if I may read, my lord. In computing the period of limitation for any suit, the time during which the plaintiff has been prosecuting with the diligence other civil proceeding, whether in a court of first instance or of appeal or of revision against the defendant, shall be excluded where the proceeding relates to the same matter in issue and is prosecuted in good faith in a court which defect of jurisdiction or other cause of a like nature is unable to entertain. Kindly see 2 also for a minute. In computing the period of limitation for any application, the time during which the applicant has been prosecuted with due diligence another civil proceeding, whether in a court of first instance or of appeal or revision against the same very party for the same relief, shall be excluded where such proceeding is prosecuted in good faith in a court which, from defect of jurisdiction or other cause of a like nature, is unable to entertain it. And now recently the Honorable Apex Court relies upon this, saying that this is to be considered as an expanded gate to allow a grievance to be entertained. Now kindly have that recent judgment, my lord. Lord would kindly have, I'm sorry.
This 1075 was filed where?
In NCLAT, my lords, to withdraw the undertaking on 8th June 21. May 21 was the earlier COMAP order, where this court said that you don't have a board resolution, therefore we can't go ahead. So within 7 days of getting a negative.
That withdrawing the undertaking is to help you to to convene a board meeting to give a authorization to the.
Indeed.
That's all.
That's all. There is no other fact to it, which they have challenged. They have sought a stay not granted.
And by the time the injunction order was passed, when you filed this application?
The application was filed in June 21. The impugned order was passed on February 2022.
In the injunction application?
In the main suit.
No, injunction?
Injunction was February 21, trial court. Trial court said no injunction can be granted because 430, prima facie view, suit not maintainable, and we are dismissing that there is no board resolution. February 21. I came to this honorable court in a commercial appeal. May 21, 27th May 21, this court dismissed my commercial appeal, saying that whatever the trial court has done is correct. Within 7 days, I go before the NCLAT that, boss, I have suffered 2 orders because of not having a board resolution, because in good faith, I had given an undertaking which is being extended. Please let me withdraw my undertaking within 7 days. Meanwhile, this Order 7 Rule 11 is filed by them. And in February 2022.
Now, what happened to the memo?
The memo, they've challenged it, they've sought for a stay, no orders have been passed. 4 times they have mentioned it. No orders have been passed on stay or seeking.
Or even in the IA.
Even in the IA. It is next listed on 18th of March, Tuesday.
So without a board resolution, you could not have cured the.
I couldn't, no. So there is one part to it, my lords. The ground taken by me in the temporary injunction as well as in the main suit is that this CFO is a principal officer. Under 29(1), a principal officer is authorized to sign on behalf of the company. So therefore, irrespective of whether he had a board resolution or not, hence he could have done it.
Yes, company secretary.
Company secretary. That is the ground I had taken. And that is the ground that I argued before this honorable court also in the earlier commercial appeal. And that is the ground in the before the Supreme Court also. But now when I come back, my lords, one of course is that ground. Therefore, the honorable Supreme Court said all questions of law left open. But to ensure that my rights are not affected, because what is the outcome? The outcome is that despite a stay on the trademarks, all courts have held against them. Still, the marks are being used today.
But your plea of as a principal officer was accepted.
The plea of principal officer has been delegated back to this honorable court by the Supreme Court's latest order of 17.
And what about was there any company secretary also?
There was no company.
Yes, so was CPC.
There is no company secretary.
There was company secretary.
The CPC 29(1) says only principal officer. But today that may not be of relevance for one reason, that I have a resolution now. The resolution simply says whatever act has been done by X person, which is the CFO, is perfect.
That's after now.
That's now 15 January. And the law is clear that any act done in good faith can be ratified by the board of directors at a consequent stage. There is no problem with that. I mean, my laws are very clear on that. Now, so therefore, coming back to this recent judgment of the Honorable Supreme Court, my lords, where 14.2 was considered and what is the interpretation to be given is important, my lords. Can I just take 2 minutes on that? My lord would kindly have, this is 2024 SCC Online SC 482. As recent as 2nd April 24, my lord. I've given a copy, my lord.
2024?
SCC Online SC 482. I've tendered 2 copies, my lord.
Yes.
My lord would kindly have para 9 for a minute. They are considering the issue of exclusion of time period under section 14 of the Limitation Act at this stage. That is what I'm trying to persuade my lordship for too. Then kindly come, my lord, to the submissions, because it will be important what was the issue before the Honorable Supreme Court. Kindly come to para 15, which is just the very next page, my lord. May I read, my lord?
Yes.
Learned counsel for the plaintiff has submitted that the reasoning of the Learned High Court that the plaintiff had chosen a wrong forum and is not entitled to exclusion of time runs, contrary to the law laid down by this honorable court, that the provisions of section 14 of the Limitation Act 1963 are meant for grant of relief where a person has committed some mistake and such provision should be applied in a broad manner. Furthermore, the provisions of section 14 of the Limitation Act is parameteria to the provisions of section so-and-so. We can just skip that, my lords. Then kindly come to para 24. There is where the consideration starts. Para 24, the very next page. May I read, my lords?
So the principles are well settled now. Very well. We'll consider it has to be seen in the facts.
I understand, my lords, but the point that is emerging from this judgment is that ultimately section 14(2) is to be given a wide scope to meet the ends of justice. It is not as if I was unable to pursue my remedy because I chose not to. In my respectful submission, I would say. I was unable to pursue my remedy because of a court order, because of the NCLAT undertaking, which I have just produced. I have shown that. And I had suffered 2 negative orders by the time I had to file this appeal. And one was a court of by the same very High Court in a division bench. I had suffered on the very same issue. My lord had put this question to me in the beginning, that the trial court's temporary injunction order was only qua the authorization. However, my lords, there was an obiter. There were observations in that order which said that because proceedings are pending in NCLAT and NCLT, the suit itself is not maintainable. There was observation. It was not dismissed on that ground. It was not rejected on this ground, but there were observations. Similarly, that order was confirmed by this honorable court in a detailed judgment, which is also on record, relying upon the same very facts. And then I went to the Honorable Supreme Court. Now, any litigant, my lords, in my humble submission, would expect that if the same very issue between the same parties has been decided, my lords, it is very obvious for the respondent to come back and say, because there was no stay, admittedly there was no stay before the Honorable Supreme Court, to say that this issue would be covered by the previous judgment. And hence I would have suffered another dismissal. And then again, I would have had to go to the Honorable Supreme Court.
Right, but there's no ground that I'll wait.
No, my lord, I'm trying to justify.
See, what is really, there were two grounds.
My lord.
On the other ground, you did not really agitate. You may say, argue that the second ground also depends upon the outcome of the first ground.
Indeed, my lord.
That's right.
Indeed, my
But
lord.
surely, that's about what we are putting. If the Supreme Court was to reject your, this thing, the SLP,
My lord.
what would have followed?
The,
This has attained finality.
well, in my humble submission, because the High Court's order would have been confirmed, and if I show my lords the High Court order, because of the High Court's order, nothing remains in my suit. In fact, they filing the order 7 Rule 11 is relying upon this Honorable Court's order. So technically, my lords, in my humble submission, because of the issues being decided by this Honorable Court in the previous round, which is the commercial appeal, my lords, there was nothing for this Honorable Court to take a separate view from on the same very issues.
We'll hear them, then we'll.
The judgment. Supreme. Two more minutes, my lords, I would need. Indeed, my lords. Take out the page, the trial court. 20th February 20. 20th February 21. Take out the page number. Last connection. Did you file this SLP? The SLP was filed on 13th March 2023. After the suit was dismissed. After the suit was dismissed, and I wanted to, I'm sorry, my lord. The answer to that is this, my lord. My lord would kindly have the office report. I brought the office report from the Honorable Supreme Court. Can you of the delay, my lord? There was about 400 days of delay and an objection filed by the other side to not condone the delay. So therefore, the ultimate answer would have been that my SLP would have been dismissed on the ground of delay. But that has not been evidently done, my lords. The SLP rather. My lord. Lords. The answer to that is this, because in the application for condonation of delay before the Honorable Supreme Court also, and I say this with responsibility because I have the opportunity of representing the clients there also, the exact thing that was taken was this application which is pending in NCLAT. Because it is my last resort, I say that indeed, my lords, and it is listed for 25 times. That's the ground taken.
Let's say that for this pendency of SLP, I was waiting for SLP to be decided is not a ground.
Well, in 14.2, that may come to my rescue because there is one reason for that. It is between the same very parties. My SLP has not been dismissed on the ground of delay today. The SLP, in fact, has been remanded back, opening everything, despite the fact that the other side opposed on the date, on the last date when the matter was decided, that please dismiss it on the ground of delay. I say that with responsibility. So therefore, when this recent judgment, which I am relying upon, yes, that is number one. There's also second leg of my argument. The office report I've given, just to be fair, there was 420 days delay, which was not condoned, nor it was dismissed on limitation. There is one more part to it, if I can just add, I'll just take 2 more minutes and I'll be done. My cause of action is a recurring cause of action. Even today, the trademark is being used. And the Honorable, there are judgments, to state that when it is a trademark infringement suit, ultimately this commercial appeal is a continuation of the suit, in my humble submission. When the right is a recurring cause of action, the delay will not come into picture. Can I just show that one judgment of the Honorable Supreme Court, which says that for trademark infringement suit, because every day there is an infringement. And my COMAP, I have not suffered it. I have not had the benefit of injunction even for a single day. Indeed, Manoj. Subject to the fact that this order will not come in my way. I have absolutely. The present impugned order should not come in my way. No, Malod. Malod. What I'm trying to reach at is, Manoj, this particular appeal, Malords, is a continuation of the suit. Since it is a trademark infringement suit, there is a recurring cause of action. Hence, limitation for a trademark infringement suit, even at the suit stage or at the appellate stage, may not come in my way if I have not had injunction. I understand that a party would have suffered injunction and then filed an appeal 2 years later. I understand that. Today, my case is that I have not had injunction even for a single day. So therefore, I would suggest, my lords, that by this judgment, which says that for trademark infringement suits, limitation is not to be seen at the lower stage, even at the appellate stage. That's point number one. Indeed, my lords. And my humble submission is that in the context of both, I'm saying, in the context of both, that if there is no limitation or delay, I would say if there is no delay to be seen at the ground level for filing the suit at the first instance, the same principle would apply, my lords, in my humble submission, at the appellate stage as well, for a reason that I have not enjoyed injunction for a single day. That's number two. And there is one last part to it, my lords. The most important part to it, my lords. The proposition that I advance that if I file a fresh suit, this order will come in my way, my lords, the present impugned order. So if my lords would have to simpliciter clarify that if a fresh suit is filed, this will come on 2 grounds, my lord, because the relief that I've claimed here and the relief that I will claim in the present suit, my lord, would be identical. The new suit, the reliefs and the parties would be identical. Now, there is a finding in the impugned order that whatever reliefs you are claimed here are pending before the NCLAT, which is erroneous on facts also, I can show that. So hence, if I have to claim the same very relief, it will be barred by res judicata, saying that same relief, same parties on the same cause of action. Maloj, the conclusion was on 430 and authorization both. Even on in the temporary injunction, yes. In the temporary injunction, which has now been remanded back to this Honorable Court by the Honorable Supreme Court, and the earlier judgment which was passed by this Honorable Court, that was on the merits also. And it was not just on merit. I'm sorry. Maloj. By Friday, Maloj?
When would your lordships want to hear us, Malod, on the delay aspect?
No, Mr. Mehta, he has argued the delay application.
Mhm.
So he has justified it. He is trying to justify it that he was pursuing the remedy before the
I
Supreme
heard.
Court and before the NCLAT or
I
NCLT.
please, Malod,
So
I contest that, Malod.
we will hear you on the next date.
Very well. I contest everything that my friend has said, Malod. Lordships would hear us. Yes.
Just say we have heard the learned counsel for the appellant on the application for delay to come up with the submission on behalf of the respondents. Just give a date.
Whenever it's convenient to the court, Malod. Deep reply, most grateful.
Milords, can it be a week before, if not an issue, Milords? Can it be 27th of March?
It's for my submission, Mr. Kalra, if you don't mind.
27th. I have to travel, that's the reason. I'm not available on 4th for some reason, so I have to travel from 10. 27th, 27th March would be convenient. 27th
But that would be
27th,
difficult. But that would be difficult for me, Mr. Kalra. May just keep in mind that I also have to argue. If it could be 4th, my lord, or 3rd of April, if that's convenient, not to the court.
Milords, I'll discuss with them and we'll give the date, whatever is convenient.
I'm so deeply obliged, because I'm so sorry for the inconvenience caused.
Grateful, Milords, deeply grateful.
Obliged, deeply obliged.
Serial number 26. Further arguments 26. The Tejas, the BB party.
My lords, for the appellant, my lords, senior counsel is just logging in.
My lords,
Mr. Raghavan is logging in, my lords. He's logging in, he's appearing on.
it's actually, my lords, I'm also being led by Mr. Holla. Requested him to come. He's just on his way, my lords. Just one. My lords, I follow. My lords, there is a very short synopsis and some judgments, my lords. I just pass. My lords.
Please.
My lords, is it possible on Monday? Mr. Holda is not available on 18th and 19th. Is it possible to have it on Monday?
My lords, Mr. Raghavan is just logging in, my lords. He's.
I'll commence, my lords. I'll commence. I'll commence, my lords. I'll commence, my lords. I'll come. But I'm just filing a very short synopsis and I'll check. My lords, first I'll address on impleading, my lords. The contention insofar as impleading is concerned, my lords. My lords, I'll file it.
But the short question, my lord, that was raised was whether, my lord, we are entitled to be impleading. And my lord, they rely upon one judgment saying that, well, it's not permissible to be impleaded. My submission to your lordship says, if your lordship, my lord, look at, my lord, the order, I mean, the factual matrix, IDBI, my lord, as per the terms of the statute, was required, my lord, into a joint, my lord, lease cum sale deed. If it does not, the entire thing, my lord, becomes odious. Can I request your lords to look at, my lord, the act itself for a minute and the regulation? If my lords take, and my lord, we have also kept that, my lord, along with that submission that we have, that act we have placed for my lord's consideration. Yes. My lord, page 13, 1-3.
This is what the Karnataka Industry Areas Development Act. 34B, my lord, get that at the bottom.
Yes.
On the left column. Where the board is the opinion that any allotment of any premises.
Yes.
Where the board is of the opinion that an allotee of any premises or part thereof or residential tenement in an industrial or industrial estate, area or industrial estate has violated any of the terms and conditions of allotment or holds it without any authority, it may without prejudice to section 25, give notice to the allotee, such allotee, banks and financial institutions in whose favor the board has permitted the mortgage, leasehold right of the premises or residential tenement, specifying the breaches of the terms and conditions of the allotment, calling upon the allotee to remedy such breaches within the time stipulated in the notice. This, my lord, is the section on which, my lord, they are relying upon. Now, my lord, please look at the
Section 41.
Section 41 on the next page, my lord. Page
14.
14, 1-4. Their contention is, my lord, 34B has to be followed by KADB. They have to be, my lord, issued notice, all that. But look at, my lord, section 41, and I'll take the regulation. And, my lord, a judgment of the Honorable Supreme. Section 41, my lord. Board may, with the previous approval of the state government, by notification, make regulations consistent with this act and the rules made thereunder to carry out the purposes of this act. Without prejudice, my lord, particulars, my lord, they'll have to, my lord, if your lords come to, my lord, serial, my lord, next page, B, in particular and without prejudice, 2, without prejudice, the generality of the foregoing power, such regulation may provide for time, place of meeting of the board and the procedure to be followed in regard to the transaction of business at such meeting under section 8. Then B, my lord, terms and conditions under which board may dispose of the land. Now, my lord, please come to, my lord, the regulation, which is framed in terms of this. My lords, come to, my lord, page
20, sir.
2020. Regulation 10, my lord. Board on being satisfied, board on being satisfied that the person, well, regulation 10, my lord.
Allotment.
Yes.
Allotment, yes. Board on being satisfied that the person, firm or company who made an application is likely to start production within a reasonable period and is not one which is declared obnoxious under regulation 14, may make an allotment in their favor. B, board may constitute subcommittee for considering the allotment of plot and other and also delegate its powers to the executive member if necessary. Executive member C shall notify such applicant to whom an allotment is made to execute the agreement in form 3 and 4. Statutory forms are there. Form 3 or 4 or 5, as the case may be, with such modification as may be necessary in each case, on such date, time and place, as may be fixed by the executive member, and to pay the consideration for the occupancy of the land as fixed by the board within the time fixed by the board. D, my lord, this is the most important one. Failure to execute agreement or to pay the sums demanded by the executive member as per the notice given under regulation 10C will render the allotee to have deemed to have declined the allotment. In the instant case, my lord, KDB asked them to, my lord, execute, my lord, the lease cum sale. They did not, my lord, do it. And, my lord, a lot of time passed. In the meanwhile, my lord, the land, my lord, was given to me, allotted, my lord, by a high-level committee, my lord, as provided under the Industries Facilitation Act. My lord, sorry, my apology. Then, my lord, please come to the next page, 12. The board may at any time, regulation 12, may at any time revoke any proposal to dispose of any plot of land, plot or area under the regulations, under these regulations, if it is its opinion, land covered by such plot or area has to be reserved for any purpose in furtherance of the objects of the act. That, my lord, strictly may not apply. Then, my lord, please come to, my lord, the industries. You are not produced that industries facility.
First.
My lord, please come to, my lord, the industries facility. Karnataka has, my lord, an act called the Karnataka Industries Facilitation Act. So please come to page 11, my lord, of this very compilation.
Sorry, sir. Full act.
Full act.
Sir, I have the full act.
Section 6, my lord, if you look at, my lord, what happened was, earlier, my lord, there used to be, my lord, various authorities. They, my lord, made it what is known as a single window agency.
And this Act, my lord, Facilitation Act provides for it. Regulation 6, my lord, Section 6. State government may by notification constitute a single window clearance committee for the state, called as the state level single window clearance committee, under the chairmanship of the minister in charge of major and medium industries, consisting of such members as may be specified therein. State level single window clearance committee shall examine and consider the proposal received from the entrepreneurs relating to the industrial and other projects to be set up in the state with an investment of more than 15 crores of rupees or less than rupees 500 crores each. Then, my lord, section, my lord, 8. Sorry. Next page, my lord, section 8. The state level single window clearance committee shall be the final authority for granting approvals for the projects placed before it. Approvals given by the committee shall be binding on the departments or authorities concerned, and such departments or authorities shall issue the required clearance within the stipulated time, subject to the clearance compliances of by the entrepreneur with the provisions of the applicable central and state acts or rules made there. Therefore, my lord, here my submission to your lordships is, my lord, threefold. One, they, my lord, the IDBI, my lord, refused, the appellant refused to, my lord, execute a lease deed, lease cum sale deed, which is a mandate requirement. And, my lord, therefore, my lord, by virtue of, my lord, section 41 read with regulation 10 D, they, my lord, their allotment, my lord, is deemed to be, my lord, non-est. Therefore, my lord, thereafter, my lord, this land was available. We went before, my lord, the single window clearance agency high level committee, which was comprised of, my lord, the chief minister and, my lord, all the authorities, my lord, under the state, all the secretaries, my lord, of various departments, including, my lord, the HUD, my lord, under which, my lord, the KDB Act, my lord, Karnataka Industry Areas Development Board, my lord, functions. And, my lord, they allotted it to me. Therefore, my lord, I have a right to, my lord, come on record. This is one. Secondly, my lord, may I request your lords to look at, my lord, a judgment of the Honorable Supreme Court, where under identical set of circumstances, though, my lord, under the Orissa Act, Industrial Areas Act, my lord, the Supreme Court has held that, my lord, the appellant before your lordships would have no right. Please look at, my lord, the judgment that I have given to your lordships. 2017, 5 SCC 86, my lord. Sorry, my lords. Please come to, my lord, paragraph 3. Page, my lord, the judgment starts at, my lord, page 1. Please come to page 7, paragraph 3. Initially, the state government had agreed for equity participation of 25 crores towards the cost of land. This offer was withdrawn by the state government on 2/2/1995 and was communicated to MESCO. IDCO wrote a letter dated 21/3/1995 to MESCO to deposit the land cost in 20 half-yearly equal installment, and further requested to deposit 1.25 crores towards the first installment, 13.08 crores lakhs towards the ground rent and cess. MESCO deposited 1.25 crores with IDCO, my lord, it's equivalent to, my lord, our Karnataka Industrial Areas Development Board, on 3/4/1995. On 13/6/1996, IDCO requested MESCO to take over possession of 1,756.29 acres of land in the first phase and to submit a draft lease deed for execution. MESCO took over possession of the land on 18/6. However, lease deed was not executed. Thereafter, on 13/10/97, state government intimated the proceedings of the meeting held on 26/9/1997 to IDCO, requiring it to execute the lease deed in favor of MESCO and also to realize the installments due. On 27/10/1997, paragraph 4, IDCO requested MESCO to submit the draft deed of lease agreement for execution within 15 days, failing which steps will be taken for cancellation of the allotment and resumption of the land. IDCO again requested on 26/11/1997 to submit the draft deed of agreement for execution. However, MESCO kept quiet, failed to get the lease deed executed. Thereafter, for more than 5.5 years, nothing happened. No steps were taken by MESCO to get the lease deed executed. Thereafter, IDCO gave final notice to MESCO on so-and-so to deposit the balance defaulted amount of 22.44 crores along with statutory dues and to execute the lease deed dated so-and-so, failing which it will be intimated that the land shall be resumed at their cost and the amount paid shall be adjusted towards the compensation for use and occupation of the land. Apart from that, MESCO shall also be liable for damages. Ultimately, on 25/7/2003, On failure to get the lease deed executed, land was resumed and possession letter dated so and so for 7,756.29 acres of land was cancelled by IDCU. Amount of 1.25 crores deposited by MESCO was forfeited and adjusted towards the compensation for use and occupation of land and damages. Now, my lord, please come to my lord paragraph 8 on the next page. It was submitted by the learned senior counsel on behalf of the appellant that the High Court has heard in law in setting aside the order of resumption of land as there was failure on the part of MESCO to get the lease deed executed despite repeated reminders made by IDCO in the year 1996 and 97. And thereafter, for several years, there was a lull. Ultimately, after issuance of notice, resumption of the land was made, which has been subsequently allotted to other industries, and the remaining land was required for their failure, for their future expansion. Sorry. The land for mining purposes is also not available at present. Installments were also not deposited. In the absence of execution of the lease deed, relationship of lessor and lessee never came into being. As such, 3 months notice of resumption of land was not required. 3 months notice is required to terminate the lease deed. Order of resumption was passed, and pursuant thereto, possession has rightly been taken as MESCO was not vested with any right to retain possession, having failed to pay installments and execute the lease deed. Order passed by IDCO for forfeiture of the amount deposited to the tune of 1.25 crores was fully justified in the facts and circumstances of the case. No development had been made by MESCO on the land in question. Thus, the impugned order may be set aside. Then, my lord, please come to para 11 on the next page. My lord, there was a memorandum of understanding, my lord, memorandum of understanding was executed. My lord, the general conditions are there, my lord, paragraph 18, para 12, my lord, I'll skip it. Please come to paragraph 13. Aforesaid condition, number 18, never came into force and remained inoperative in the facts of the incident case as lease deed itself has not been executed. Even otherwise, more than 3 months' time was given to MESCO to remedy the breach, inasmuch as notice for resumption was initially given in 1997 and more than 5.5 years till resumption in July 2003. Breach was not remedied. In spite of receiving the advance possession, there was failure on the part of MESCO to execute the lease deed, though draft lease deed was sent to it in January 1996 for execution. Relationship of lessor and lessee never came into being. In the absence of execution of lease deed, the execution of lease deed was necessary as state government had only accorded in principle approval and advised IDCO to allot the land that could only be done by execution of lease deed. As a matter of fact, IDCO ought not to have handed over advance possession of the land to MESCO without execution of lease deed. However, for the reasons best known to IDCO, advance possession was given. Allotment letter itself contemplated the execution of the lease deed as a condition precedent. As provided in section 33 of the Orissa Industrial Infrastructure Development Corporation Act 1980, the corporation can dispose of the land subject to directions given by the state government in such manner and subject to such terms and conditions as may be necessary. Condition precedent was that execution of the lease deed, and as it was so directed by the state government also, in our considered opinion, no concluded contract came into being and transaction became void due to failure on the part of MESCO to execute a formal lease deed. Ultimately, my lord,
this provision is
in fact, para 33, my lord, the next paragraph, it's para 14, if your lordship sees, my lord. 33 is akin to, my lord, our 34B.
No, so 41.
Sorry, 41(2).
Regulation.
And regulation, sorry. 33, innondu idanu nodi. One section is also there. I showed you yesterday.
That is separate again.
Separate, you have kept it separate. My lord, we have got that Orissa Act also, my lord, I'll point out. My lord, para 33, my lord, is akin to, my lord, section 41 of our Act. Disposal land by the corporation, subject to any directions by state government, may dispose of any land. 41(2)B, my lord. Then please turn to, my lord, para 16 on the next page. In the instant case, it is apparent that possession had been enjoyed by MESCO without execution of the lease deed. Conduct of IDCO was also not diligent. Notice was served in the year 1997 for resumption, but thereafter, up to July 2003, nothing was done by either IDCO or MESCO. Not even a single communication has been placed on record by MESCO containing its proposal to remedy breach. And on a specific query being made to the learned counsel appearing for MESCO, they were unable to explain as to what transpired between 1997 to 2003, except vague submission was made that it was mired in certain litigations, which fact has not been pleaded. There's no explanation, good, bad, or otherwise, has been placed on record, inaction, etc., etc. Then, my lord, paragraph 17. IDCO is a statutory authority and it can act only on the basis of written lease deed. Execution of lease deed is necessary and it is in public interest to prevent unauthorized leasing out of property on its behalf. Lease is required to be executed in a prescribed format in the shape of formal document, which is a sine qua non. In the absence thereof, it would not be permissible to hold that relationship of lessor and lessee came into existence, came into being. Para 18 on the next page. It is apparent that there is a manner for executing the lease deed with the corporation. The prescribed form of draft lease deed has been sent by IDCO to MESCO, but it failed to execute it. Thus, there was no contract which could have been enforced and it became void due to inaction of MESCO itself. Then, my lord, paragraph 22, my lord, their lordships, my lord, the Supreme Court set aside the order of the High Court, and then, my lord, ultimately, my lord, they hold that order, my lord, paragraph, my lord, the last paragraph, my lord, at page 18. The order of the High Court was set aside because High Court, my lord, set aside the order passed by IDCO. For, my lord, saying that we have now cancelled everything, it's not. Therefore, my lord, my submission is that. Then, my lord, the judgment, no, sorry, Orissa Act, my lord, just I'll point out one provision.
Sir, page 20.
My lord, in that compilation of, my lord, authorities that I had, sections, synopsis I had given to your lordship. Please
Page
come
23.
to page 23, my lord. Orissa Act,
Section 34.
page 23. Bharat, my lord, section 33, disposal of the land by the corporation.
33 is what is extracted. 34 is acquisition of unauthorized industrial allotment to other industry.
Equivalent over this thing, I say.
Sir, that is, sir, 34, 4 notice. Sorry, 34, 3. Yes,
So, Lord, please come to my lord 34.3 at page 24. Page
yes, sir, 24, sir, 20.
Page 24, subsection 3 of my lord, section 34. If the board is satisfied that any plot holder has not utilized the maximum area of his plot suitable for construction of building for a period of 3 years or more from the date on which the possession of the land was delivered to him by the board, and the utilized portion is capable of subdivision so as to make it useful for any other purpose under this act, board may, notwithstanding anything contained in any contract or in any law for the time being enforced, issue on the plot holder and all other persons interested in such plot notice to show cause why such unutilized portion should not be acquired for the purpose of being utilized for any other purpose under this act. Board shall also cause public notice and order. Now, my lord, please contrast it with section 34B. My lord. Yes. Oh, I'm sorry. My lord, my apologies. My apologies. Yes. Please.
It's passed over matter. No, it's passed over matter. Right.
My lord, is it on Tuesday, my lord, hours? Tuesday, guys. Oh, okay, very well. Because 18th, 19th, I have some inconvenience. Any other date, my lord, I'll be before my lords. Eighteenth and 19th, my lord, I'm not in town, my lord. Sorry. Please.
My lord, I appear for the appellant.
My lord.
Can I request, my lord, for a date after 26th if it is possible, my lord? 24th, I am not in town, that's why.
My lord,
please, my lord.
serial number 35, my lord. My lord.
15.
Serial number
15.
Correct, one ನಿಮಿಷ. ನಾನು ಫೋನ್ ಮಾಡ್ತೀನಿ. ನಾನು ಫೋನ್ ಮಾಡ್ತೀನಿ. Yeah, I'll ask. Madam, 26th,